Your Lordship, I beg to mention item number 1, Your Lordship.
Item
Number 1.
1.
Yes, the conducting counsel is feeling unwell today, so
Just renew the prayer when the matter is called. Please renew the prayer when the matter is called. Correct. Just wait for some time.
Headquarter substitution.
What is the stand of the government here?
yes, since Your Lordship.
My lord, our statement will be finding affidavit by paragraph 6, saying that, my lord, these two places will be developed just like a Nard and Eternal twin capital fashion, my lord. Paragraph 6 of the affidavit, my lord. Although bowling will be the permanent headquarter, but it will be developed like a twin capital fish style, my lord. Page 4, paragraph 6, man.
Six. B.
Okay, then we adjourn the matter.
My lord.
The prayer made by learned counsel for the petition, the matter stands adjourned today. Mr. R. Nawam, learned. R.S. Nawam, learned additional advocate general, assisted by Ms. P. Kangu, learned government advocate, is present. List after
4 weeks. 4 weeks.
4 weeks.
May, Lordship.
Amicus curiae in the matter.
Amicus curiae list.
JLP. As the appeal is preferred from jail under section CRPC.
CRPC.
CPC. This here, huh? These books.
Lordship, may I, Lordship?
Yes.
Lordship, I'm legal aid of counsel, Lordship, appearing for
You are the legal aid counsel. Okay.
Lordship, yes.
Okay, then it's okay. The paper book is ready.
Lordship, we have received the paper book, Lordship.
So
Lordship,
LC is
last
also
occasion.
received. Yes,
Okay, Lordship. Lordship, last
Yes.
occasion, victim informant was issued notice, Lordship, returnable in 6 weeks, Lordship. That, Lordship, I find that still steps is to be taken, Lordship. I've seen the record, Lordship.
no, this is life set. What is the offense?
Lordship,
302.
302, Lordship.
So in 302 is not mandatory to send notice to the informant.
Lordship, all right, Lordship.
Because
Then
the
we can go
ATT
ahead with hearing, Lordship.
So the ATT will take care of it.
Lordship, in that case, Lordship, we can go ahead with the hearing, Lordship. We can fix it for hearing, Lordship. Fix a date for hearing.
This has it appears from the office note dated 4/3/2024 that notice is served on the informant to the Court of Learned Chief Judicial Magistrate Dapori Jo after service. Mr. None appears on call for the respondent number 2 of the informant. Next one. As the appellant has been convicted for commission of offense punishable under section 302.
201 notice.
Along with something. 302/201/34. No, he's acquitted there.
Also sentenced to 2 years in 301,
302 and 201. Okay, 302/201. IPC. Comma. The non-representation by the informant would not be fatal. Next, as the paper book is prepared, next, this is the matter for hearing in the month of June 2024. You are there, Miss
Tijini election.
Tijini Leonard. Additional public prosecutor is present.
DPO.
Obliged, Lordship.
No, this contempt petition, the operative portion is at para 12 and 13, at page 35.
Para 12 and 13.
12, 13, at page 35. As we have not determined the contention raised both by Mr. So-and-so learned counsel for the appellants and Mr. So-and-so learned senior government advocate as to whether the appellants are working against any sanctioned post. The respondent authorities in the Department of Power may examine the claim of the individual appellants and determine as to whether any of them are working against any sanctioned vacant post and whether they have worked for a period of 10 years or more up to 10/4/2006, that is before Uma Devi law. And without the aid of any court order, if all the three conditions are satisfied, we are of the view that the provisions of paragraph 53 of the pronouncement of Supreme Court in Umadevi Supra would be applicable and the relief of the regularization be entitled accordingly. Now, para 13, my lord. On the other hand, if upon verification, it is found that any such appellants are not working against any sanctioned vacant post, but are in employment and performing work of similar nature, quality and quantity as that of an equivalent regular employee, the relief of providing wages equal to the salary at the lowest grade of employees of their cadre be provided to such appellants. Further, if upon examining the individual cases, the department finds that any of the appellants are in employment, but are not performing the similar nature, quality and quantity of work as that of an equivalent regular employee, the other relief provided in the judgment dated 17/1/2017 for an adequate financial package to be provided to such appellants. Now, my lord, the affidavit, since their lordships are on the contempt jurisdiction, I need not to make much submissions. Only, or otherwise, my lord, to point out few things. Kindly have their affidavit below. The voluminous affidavit. My lord, what had this filed by the respondent number 4? My lord, what had happened after this judgment, my lord? The department, the container, alleged containers had constituted an expert committee, tried to overrule the decision of this honorable court, my lord. How it happened, my lord? Kindly come to chapter 5, page 35. 35 of this affidavit in opposition. Filed by respondent 4. Internal page 29 of their findings, my lord. Page 35. My lord will kindly come to serial number 4 straight. On 10 years criteria, that is what has been directed in the paragraph 12, my lord, of the judgment. Out of 68 petitioners, only 48 are participating in contempt case, 31 AP so and so. B, my lord, 31 out of 68 qualify the criteria of having completed 10 years of service as on 10/4/2006. Now, this exactly, they have also have this summary of findings saying that they are well within their knowledge that paragraph 12 is on their head, my lord. C, my lord, 8 of them got promoted to WC during the pendency of case based on regulatory scheme. Now, my lord, another thing, my lord, kindly
just
come.
now.
Yes.
Yes.
Now, my lord, will kindly turn to page 37 and 38. Yes. An opinion before conclusion, my lord. Page 37. my lord. Well, this is only then page 39, 3 pages, my lord. Let us read together. Opinion before conclusion. Scope of the committee to make recommendations. Although making any recommendations and suggestions to the government is seemingly beyond the scope of the committee as per term of reference, we would like to venture to make an opinion the competent authorities may ponder upon. If found reasonably sound, we are of the feeling that such court cases would continue to come in future, given the present situation of fixed WC posts in all the engineering departments, and for extra financial burden, creation of new posts are not being encouraged. For the same reasons and purpose, casual laborers are repeatedly frequenting to knock at the doors of the court for possible remedy. Such cases are taking away so much of valuable time and money of the officers concerned at the cost of developmental works. On any occasion, such cases are not attended timely due to lack of time, which leads to judgment unfavorable to the department. The present contempt proceeding instituted against the respondent authorities in the contempt case C31 so and so is one of such a glaring examples. Sometimes in the situations, the department end up doing what was not wanted to be there by causing heavy expenditure from the fund meant for development of the state. Now suggestive, my lord. Desire for growth and progress in job profile and pecuniary considerations are natural character of all human beings. Further, here they become very philosophical, my lord. Further, we can expect dedicated service, mostly from those workers who have sense of minimum level of job security and expected progressions. Keeping the moral of our human resources is as important as achieving the target successfully. In fact, it is synonymous with the success of human resource management. B, my lord. B is important to be noted, my lord. We feel that the government may ponder over inducting all those who had served at least 15 years continuously as casual labor into WC category by converting the 10% of casual laborers annually and thereby reducing the number of casual labor 10%. But just I'm pausing for a moment. My lord is aware that Uma Devi's judgment. Now, prior to Uma Devi judgment, my lord, that Maharashtra Direct Recruit Engineering judgment, 1992 SSC page 715, my lord. So in that particular judgment, my lord, they are trying to overcome this ratio. Uma Devi says 10 years, and they're trying to prescribe a new guidelines, my lord. And then if Uma Devi is to be construed in this manner.
In direct recruitment 2 case, it was the regular, what you call advertisement and regular appointment.
Yes, my lord. But still, those constitutional bench judgment, my lord, has a relevancy in this.
I think the report.
Yes.
Government has accepted and conceptualized that in the affidavit that is there in the main file.
Correct.
That is at page 6. So then we have to examine that whether that amounts to a contempt.
Yeah, that's why, my lord, with all humility in the opening remark itself, I have submitted before their lordship that it is a contempt jurisdiction, whether the contemptor has actually committed a contempt of this honorable court's order. And just as a duty-bound court officer, my lord, my duty is only to point out where they have faulted and where they have tried to play with the sacrosanct judgment of this honorable court, my lord. And I have nothing much to submit, my lord. Only these much kindly see there at page 39, my lord. It is whatever the findings they made, and my lord, their report is on 2nd February 2023 after the judgment was rendered. So therefore, my lord, at the altar of these great visors who want to override the decision, the judgment directions of judicial order of this honorable court need to be dealt with an strict hands law.
Lordship, firstly, Lordship, we need to understand the Lordship instead of
Just yes.
no. See, in order to regulate the laborers in the department Lordship, we have a regulatory scheme Lordship, formulated by the state government Lordship. That guides the Lordship how this employment has to be given to the laborers and how they have to be promoted from unskilled to skilled, then double C Lordship. And that was earlier Lordship by some another petition. It was even challenged before this honorable court. The regulatory scheme Lordship. And this honorable court has dismissed and upheld the regulatory scheme. That's even the judgment has been annexed. Now coming to the present case Lordship. There were Lordship three-fold directions given to the state respondents Lordship. The first, whether Lordship the petitioner comes under the exceptions given in para 53 of the Uma Devi case or not Lordship. That part that was examined even by constituting a committee. It was examined Lordship. We have found that Lordship they have not been appointed against any sanctioned posts, and so per qualification all Lordship those part Lordship we have Lordship denied Lordship. Then the paragraph 53 goes Lordship. The second Lordship, whether they are Lordship they are working the similar nature of works with same quantity or not Lordship. That aspect also Lordship the committee has touched. And it also has gone Lordship. We found that Lordship, no, they are just assisting the Lordship, the WC worker Lordship, who has been given a particular trade Lordship. These laborers are not given any.
Where is the finding with regard to they are not appointed in any sanctioned post?
Lordship, kindly come to my affidavit Lordship.
Page.
Affidavit, page 6 Lordship. Page 6 is the page 6, my affidavit Lordship.
That's an annex.
Affidavit is
No,
annex
it is
1.
in
Main affidavit Lordship. This is the Lordship the order passed by the authority in compliance of the direction given by this honorable Lordship.
Yes.
If Lordship turn next page, that's the page 7 Lordship. I'm taking Lordship to the fifth paragraph, and whereas it is start from and whereas Lordship.
Yes.
And whereas the reports tendered by the finding committee has been examined in the department and the department is inclined to agree with the recommendations of the committee. On perusal of reports submitted by the fact-finding committee, it is revealed that the petitioners who are casual workers were not appointed against any regular sanctioned post. They were raised to assist the work charge employees or regular employees. The works in the department comprises of many trades and work charge regular appointments only against the particular trade subject to qualifications and availability of the vacancies. Yes, no?
Work charge employees also require
Assistance.
Lordship, work
And
it's not
ask
the
one officer who have the assistance of what you call helpers.
here Lordship assist in the sense they assist, they help.
No, I don't know.
work.
I'm not commenting. I'm just thinking aloud. What's the employees having assistance?
someone has to assist the painter lawsuit to carry the paints and all lawsuit.
Good
So
presence
those
of,
sorts of the works
good presence of mind.
lawsuit. And and when lawsuit one is appointed against a particular trade, that's in worksite, they have been given particular trade laws like painter, mason, lawsuit, particular charges. Even for that lawsuit, this is done. Qualification is required lawsuit. Otherwise, lawsuit. So all those are lawsuit already lawsuit stipulated in the regulatory scheme lawsuit. There is no permanent sanction post in a department mean for casual workers or the works which the casual workers are with. Therefore, there is no regular sanction post for the work which is similar to that of the works being carried out by the casual workers. Casual workers, as such, there is no permanent post. Now, paragraph 53, it goes Then, whether they educate the similar works. That part also, finding has been given by the authority, Then the last part, even though they do not fulfill these particular two conditions, paragraph 53 and then this equal pay for equal works, even then direction has been given, to make some sort of formulate some sort of policy. I'm coming to that lawsuit. The state has already formulated policy lawsuit. This is the lawsuit. It's a part of the action also. Now, even this part of the lecture. Just indicate the page like this read also. Lawsuit. This is the just subsequent lawsuit. And even in our affidavit also lawsuit, it's on page 121 lawsuit. 121 updated as revised as on that lawsuit. Page 121. It was last revised on 30 January 2019 lawsuit. And this is the updated lawsuit. After that, after 2019 lawsuit, it was revised twice. If lawsuit will find the unskilled lawsuit for 0 to 5 so and so and above 20 years lawsuit. Lawsuit will find the revised that was made on 1/10/2023 lawsuit. About 20 years lawsuit, 18,000 per month lawsuit. Now lawsuit, here lawsuit, as of
That very fairly, enhancement, they have done it. Because that, the first judgment, leading judgment on this, Raja Randhir Singh judgment, equal pay for the equal work. The 1977 judgment. This part I am not disputing.
and here lawsuit, the latest, as of now lawsuit, those who have served lawsuit more than 10 years lawsuit, they are getting 15,000 per month. And above 16 years lawsuit, they are getting 16,000 per month. And above 20 years, they are getting 19,000 per month. And if lawsuit see the pay scale in the 7 pay commission lawsuit, the lowest scale it starts from 18,000. It starts from 18,000.
Level 1.
Level 1. So therefore, lawsuit, the state government is working on lawsuit to enhance to see the welfare of the lawsuit, the laborers lawsuit.
Why was
If lawsuit,
regulatory scheme not before the
no, it was examined lawsuit. Yeah, it was examined. And if lawsuit see this very order lawsuit, here down below lawsuit, even some other facility also has been given lawsuit. To serial number 2 lawsuit, contingency employees, laborers, so and so, notified by so and so would allowance of 500 rupees only per month over and above the wage rate of so and so and so. Others condition lawsuit, that is their lawsuit. So it's not their lawsuit, the state government is just sitting lawsuit over the issue. After judgment lawsuit, it has been revised thrice lawsuit.
State is continuous.
So lastly, Lordship, whatever Lordship, rightly or wrongly, Lordship, this particular order has been passed by the authority, complying the order given by this. Therefore, Lordship, this content may be Lordship closed. If I told they are if agreed by this order, then that can be challenged, Lordship. This Lordship, next course of action, if any, Lordship. That's my submission.
We'll examine and pass orders. By the time we release it, it may be tomorrow.
Fine. Next, come on.
Problem.
Milord, today was for the suspension of the sentence, Milord. Today, oh, sorry. Appeal has been admitted, Milord, in this case, and
Here we'll hear it expedition is because of the nature of offense. We are not inclined to grant a bail.
well, Milord, I can demonstrate in 2 minutes, Milord. Given me a few minutes time, but the PP is additional PP is also not there, Milord.
We'll wait for some time.
Mr. Tado, he informed me this morning around 9 that he was discharged from hospital last night. So he could not. Milord, next Tuesday.
We'll take it on Monday next.
Milord, Monday I'll have some difficulty. I'm leaving for some works in Delhi.
Friday, then this Friday.
Milord, Tuesday, Milord. Next Tuesday.
Tuesday we have fixed matters for hearing.
Milord, Monday,
Monday you said you'll not be there.
I'll try to come on Monday.
Then Wednesday.
Wednesday, Milord. Well, prima facie, Milord, I have a case for suspension of the sentence.
Lordship, I'm for the state, Lordship. The service is completed, Lordship, and let the paper book may be made.
Expressing for the suspension of sentence.
Because then it's just 20 years, Lordship, the punishment is. So it may be hard to gather.
Milord, section
Once the,
1 point, Milord. Section
once
6,
389
the
is-
punishment is only
you have to take it up.
10 years. 10 years. But
Extend to 20 years.
extend to 20 years. But then anyway, I'll not open up today, Milord. I'll demonstrate in 5 minutes, Milord, next day.
Okay, we are fixing it on Tuesday, Wednesday next.
Wednesday.
Lordship.
Grateful.
Says the representative. It is. Mr. Tado is.
Yes, Lordship.
It is submitted by Ms.
El Hage.
L. Agil and AVP that Mr. Tado is an
APP.
APP
Lordship.
who is assigned with the matter is indisposed. So accordingly, matter stands adjourned today. List on next Wednesday.
29th, huh? Grateful.
Like,
May it please, Your Lordship. Well, this is a PIL which was filed against massive misappropriation of government funds in the Upper
Yes.
Siang district. and notices were issued. My lord, what has happened, our name was not reflected on the earlier occasion as well as today. And on
Okay.
10/4/2024, we could not appear, and the matter, an amicus was appointed, and the matter was
Okay.
fixed today. Till now, the respondents have not given their affidavit,
Okay,
filed their affidavit.
we will
So I
do
pray
the
that
appearance.
for the respondents to say.
Acha, the state is not filing a response.
Yes, my lord, this is a very serious where we could document 7 instances
My lord,
of
there
violation
are
of misappropriation
three
of public
departments
funds.
involved. In fact,
Yes.
my lord,
Service report is still awaited, Mr. Das.
My lord, on the private
fact, my
respondent,
lord-
yes. My lord, on the last occasion, it was showing that 11 to 20 service report is awaited because we have made the respondent not only the departments, the
Registered that-
beneficiaries, the contractors also.
already
part.
registered. Even after that, he is again coming by way of a PI, man.
Just a
Affidavit on record.
You file
My
it
lord,
affidavit, Mr. PIL.
They, in their own statement, my lord,
Just give me the
My
second
lord,
file.
today, my lord, my learned friend should know that they have not filed anything. They need not go for a hearing.
Service report.
Service report. My lord, our name may be reflected, Your Lordship.
Yes, yes, will service report. Maybe.
paragraph 9 and 10 of the PI, my lord, petition, my lord, at page 23.
Who is filing? Last of it.
Hmm.
Submission.
Respond number 18. Mr. Das, you will have to take first steps for just the respondent numbers 15 to 20.
Yes,
The
Lordship.
address is not known. Insufficient address.
So we'll have to take again steps.
So please take note of it and take first steps.
Yes, Lordship.
You can reuse this steps available here.
Yes, Lordship. We'll use it by register.
Mr. D.K. Das, Leonard, counsel for the petitioner. First of all, at the outset, he submits that as he and his his name and the name of his colleagues were not reflected in the cause list. He had missed the listing of the matter
On 10th.
on 10/4/2024. And on finding the petitioner unrepresented, an amicus curiae was appointed in the proceedings. First of, we note that even today, when the matter is listed, the name of the learned counsel for the petitioner is not reflected. So therefore, we accept the clause shown for non-appearance on 10/4/2024 and allow the petitioner to be represented by his engaged counsel. Mr. Patin is here, Tony Patin.
Yes.
Oh, okay. Next brother. We exempt the appearance of Mr. T. Patin, who was appointed as amicus curiae by order dated 10/4/2024. So therefore, the registry may not reflect his name in the cause list while listing the matter next. Next, the registry shall reflect the name of the counsel on record for the petitioner while listing the matter next. Next paragraph. From the office note dated 25/2024, we've seen that unserved notice on respondent numbers 15 to 20 are returned back on the ground of insufficient address. So the learned counsel for the petitioner shall take note of it and ascertain the correct postal address of the said respondents. And take fresh steps within a week for service of notice on is permitted to reuse the returned process. Next paragraph. The service report on respondent numbers 11 to 14 is still awaited. So according to the registry shall put up a note. Therefore, the registry shall examine and put up a note as regards service of notice on the said respondents. If required, by putting up the matter before the Laozima court. Next paragraph. Yes.
I appear on for 1 to 9, madam.
Achha. Mr. N. Ratan, done additional advocate general appears for respondent numbers 1 to 9. And Mr. O. Pada, done standing counsel for respondent of 10 are present. You are praying for time to file affidavit? No,
Yes, my lord, the SIC's affidavit will do.
will do.
May your lordship,
The
lordship, I'm appearing for private respondent number 13,
for 13, okay. Your name?
J. Karbak.
Learned counsel appears for respondent number 13. The learned standing counsel for respondent number 10. You want to file affidavit?
No,
No. The praise for is granted time to file affidavit in opposition in the matter. Most of the state respondents, on behalf of the state respondent numbers 1 to 9, the learned additional advocate submits that the affidavit in opposition filed by the SIC within bracket vigilance shall suffice for the state respondents. Next paragraph. The learned counsel for respondent number 13 submits that he would not be filing an affidavit in opposition in the matter. Next paragraph. List on so and so awaiting return of notice issued against respondent numbers 11 to 20. And affidavit in opposition by respondent number 10. Give a date after 4 weeks. (18)6, Mr. Das.
Yes, lordship. Oblige. Oblige.
Number 6 and 7.
Yes, ma'am.
Yeah. I would like to submit with due permission.
List of dates.
I'm not a party in this case, but I have a indirect bearing in this case now.
We can't commit to make submissions.
Praying for passover of this matter till
No,
Wednesday.
We can't do that. You see, the reason is, unless you are an intervener or respondent, we can't hear you.
I am filing writ petition or challenging the entire process. No paper
No, we
publication.
don't know. But you know the law. Can we hear a third party to the proceedings?
Only praying for adjournment of the matter.
Not at your instance.
Because any decision will affect my rights. So for miscarriage of justice.
We'll get a ground to challenge it in before the.
But I am filing writ petition, it may come with this writ appeal. I am filing my writ petition, my lord. This week, my lord.
No, we don't know. Everything is presumption. Tomorrow I may come to court is a presumption. We don't know what fate God has written for me.
My lord, no, I am only for Malini, my lord.
We can't say anything. Tomorrow is another day.
Just to avoid miscarriage of justice, man.
Because no due process was adopted. If we have a serious allegation against the district administration also.
My lord, I have prepared a short list of dates so that the factual aspect is clear. Because yesterday I have shown, prior to the award, what was the situation, whatever is the extent of land they requested, and the exact same extent of land has been acquired. This dates precedes from the award. After the award, did they take any grounds which they are raising now? This letters will clarify that, my lord. My lord, kindly have that list of dates which I have given. Lordship has that? Your Lordship has. So the first date, your Lordship will see.
I was giving my reply to the submission, my lord, on the
This is the
maintainability, my
factual.
lord.
So I'll just
And,
clarify 5 minutes, then we can proceed. This will clarify the factual narration, complete narration. Kindly have 6/9/2018. That is the first date. That's the date of the award. That is at page 175. One page before, that is page 174, that the very next day, the award was communicated to the ITBP. That letter is on record, page 174. Kindly have page 174. Lordship may keep this list of dates along with that writ appeal file. So I'll just quickly take
We
your
are not
note.
opening the file right now.
All right. So I'll just read out one paragraph of this letter 174, which is important. It says, second para, however, in relation to the letter, no reference at serial number 2 above. It is to inform you that the land required for helipad at BP and Malini are currently under government Department of Civil Aviation, therefore not included in this acquisition. If there are any additional requirement of land, the same may be communicated along with requirement for land of other BOPs not included under the preliminary notification issued by the government of Arunachal Pradesh as was mentioned. So this clarifies that helipad and all cannot be because these are under civil, this thing. The next letter, my lord, 2/11/2018. This is the first time after the award, they write back to the DM. This page 185. Lordship, may kindly have 185.
No, we are not opening the file right now.
All right. So it is 280. They dispute that 280 is very high. So can it be lesser? That is the only dispute they raise. Now, the rate card is at page 178, page number, where 178, serial number 9. It says horticulture land approachable by motorable road. All their grounds is only that it is not serial number 9, it should be serial number 19, which is grazing land. That is their ground. They reduce it from 280 to 50. That is the only ground. So on the third letter in my list of dates, the DM writes back saying that this is the government approved rate. So we cannot do anything about it. So after that, they go silent. The fourth letter, 6/12/2018, this is their internal letter. This letter, para 1, I've created the gist in the list of dates. Combined survey was done by DC and ITBP. That in furtherance, there will be a need for more land. They're still saying more land is required. Para 3, Assam Rifles has mentioned the area of land on an assumption without documentation. So they also admit that whatever Assam Rifle gave to them is on assumption. Now joint survey has been done. Para 4, presently there is no requirement of dropping zone. This is the first time they say that dropping zone has been acquired, but we don't need it. But this is their internal. This is after acquisition, after the award. And they para 5, that 280 is rates of land, 280 as land in horticultural land approachable by motorable road. This they also acknowledge that DC has written back. This is the finding. Now the next letter is 11 October 2018. This is at page 180. This is the same chart which I have shown yesterday. That chart, it is their own internal letter. That table is there, and they acknowledge everything. That this is the position. Helipad is not acquired because DC said it is civil administration. Willingness certificates only with respect to the additional land. And the last point is that the initial confusion, Anili and Italin are not part of this award, this process. This is separate. That is still pending. So after that, my lord, DC on 22nd of January 2019, notice of possession. Yes, ma'am. I was at 11th of October 2018, that table, point number 1 in the table. I'm not going to the document, my lord. From this chart only I'm reading. Point 1, area of helipad not included in the acquired area. This is their internal communication. They're admitting all these facts. Certificate of rates provided by DC. Regarding willingness of helipad, it is stated that the helipad is not required. Point number 6, regarding township land or any which is not required. That is a separate issue. These are all contemporaneous documents showing they have no grievance except that it should be 60. The rate should be 60 instead of 280. That is the main grievance. And they also raise dropping zone should be included, but this is after 10 months of the award. So there is a separate process for that. So now the next 2-3 dates are that DC issued possession of notice, which is in a way symbolic because possession was already there with them for the last more than 50 years. And then DC writes to the petitioner to pay compensation. And 6/7/2019, this is the first time they write to the DC saying that dropping zone is not required. This is almost 10 months after the award. Award was September 2018. And no other grievance. There is nothing. So now, my lord, the grievance, willingness, and all this, these are all subsequently manufactured, my lord. Now, the next page, over the page, these are the proceedings, my lord. The first single judge, 7th of November 2019, where the judge said, Honorable Judge said that the award has not been challenged. So therefore, they have to pay within 3 months. 7/10/2021 is the first writ appeal against that, which they have withdrawn. And kindly see what they have mentioned in that. Can you have this is actually not one record, so I'm just placing at this order. This is important because while withdrawing the writ appeal, which has a consequence, once you withdraw the statement, yes, kindly have internal page 3, 7th October 2021, para 3, last but one para. After arguing the matter for some time, Mr. R.K.T. Chaudhary, learned Assistant Solicitor General of India, praised that they may be allowed to withdraw this appeal so that he may pursue the matter either by filing a reference under Section 64 or an appeal under Section 74 of the Act. In view of the above, the writ appeal is dismissed as withdrawn with liberty to the appellants to pursue their remedy in accordance with the provisions of the Act. Now, my lord, going back to the chart, they filed an LA appeal. They filed an LA appeal. And on 10th of December 2021, the LA appeal is dismissed, which I have shown your lordship yesterday, page 40 of my compilation, that written note. Because these two orders are not there in the writ appeal, my lord. 7/10/2021 and 10/12/2021 is not there on the writ appeal paper book. And then, my lord, 6/6/2021 is the second writ appeal which was there. That was also withdrawn, saying we again, and this fact was not disclosed, that LA appeal has been dismissed. They still say we will go back and take our recourse under the 2014 Act. And after that, 8/6/2022, this is the observation of the single judge. He only delayed the compensation. And 15/6/2022, my lord, the petitioner was given 45 days time. Then they went to the SLP, filing in SLP. Supreme Court directed to deposit and dismiss that SLP also. Now, after that, these proceedings are again restarted with the same grounds, my lord. Same grounds, identical grounds. Now, my lord, your lordship has asked me.
Also, we asked you.
Yes.
The reference to the orders passed by the Supreme Court of India is not on record.
Supreme Court of India, I have
the withdrawal of the SLP and the payment of money. That's not a part of the record of this appeal. Yeah.
We have orders, my lord. Those orders are there.
In my list of dates, my lord, I have
Given that.
I am appearing for respondent number 7, 8, 9, and 10.
This is the first order.
One number. Order 21, 1, 2, 3, 4, 5, 6, 7.
my lord, leading to filing of SLP background is something different, my lord. I'll come to that part also.
Yes.
My lordship, I've handed over that first order, issuing notice and direction to them to deposit. There is a I guess.
Where is this the list of dates? This one, hand it out.
Both the orders, my lord,
Whatever copy you want. Just check this. Check this and check this. Check this and check this one. It may be the other way.
I have just handed over the first order. I have two copies. Second order, I am sorry, I have only have one copy. I'm trying to get it. So the first order says that actually the contempt was there. So contempt was stayed, subject to deposit of the awarded amount.
Yes.
And finally, my lord, this has become infructuous and that has been disposed of in terms of that. That is the short order. So now, my lord, if my lord, in this writ appeal, my lord, if at all your lordships go into the details and so the consequences, my lord, from all these 4 or 5 judgments, which has attained finality right from the single judge November 2019, and not only that, my lord, the award.
But the Supreme Court would have passed some orders for the money that.
Because by the time the read petition was dismissed by the single judge. So when this was informed to the Honorable Supreme Court said ki then nothing survives in that because that was on interim.
But some, as per your projection, some money was deposited.
Yes, yes.
Now, for that deposit, the Supreme Court will have to pass some orders. Otherwise, in Supreme Court, by administrative orders, money is not released.
Yes, my lord.
There had to be a judicial order for release of the money.
Very well, my lord. Yes, yes. So the thing is, my lord, that if your lordship see the 2 impugned orders which were impugned before the Supreme Court, one was the contempt order and one was the refusing to grant stay of the single judge. These 2 orders were impugned before the Supreme Court, my lord. So when the matter came up, Supreme Court passed that you deposit, we are staying the contempt proceeding, you deposit the amount. And finally, when we informed that single judge has dismissed their writ petition, so Supreme Court said then the rest will follow because there is no further orders because this direction has marched into the final order and therefore that final order will follow, which is the impugned order. So that was the reason, there was probably no observation in that. So coming back to this dates, right from the single judge order of November 2019, and even before that, the September 2018 award, all these and subsequent judgments, almost 4 or 5 judgments will be affected, which has been attained finality. There is no 2 views about that, They have not challenged the award. They have not challenged the November 2019. They challenged, but they withdraw without any liberty to come back to this court, They filed the LA appeal under the Land Acquisition Act against the award. That also got dismissed and they did not proceed further. They abandoned that completely.
Those part we have already made submissions.
Correct, my lord. Now, in that view, my lord, can I straight away go to some few judgments? I have 2, 3 judgments. I will just refer to that. Starting from this, the land acquisition. LA, this is Aishar Datta. Next is Raj Lakshmi Das. This is a case, this is also arising out of a land acquisition proceedings. So here, there was a delay. Possession was already taken prior to the initiation of the proceeding, just like in this case. And there was a delay of 17 years to start the land acquisition proceedings. In this case, it is more than 50 years. So the land acquisition, the affected party went to the High Court filing a writ petition that it should be expedited, the process. Para 1, my lord. Page 194, para 1 is the facts. I'll just read out. The appellant's claimant aggrieved against
You are in fact lucky to have the initiation of the land acquisition process. Had I been there, we would have dismissed it because of the period of limitation. For government, the adverse position runs for 30 years.
Yes, yes. Yes.
So once that is there,
Yes.
the title otherwise is conferred on the
Yes,
respondent authorities.
yes, my lord.
Yes.
Yes, my lord. Now, my lord, para 1, the appellant claimants aggrieved against the common similar judgments and order dated December 99, passed by the High Court of Himachal Pradesh, dismissing their claim of interest of 12% granted by an earlier order of the division bench of the same High Court in so and so on equitable consideration for depriving them of their lands without taking proceedings under the Land Acquisition Act, and payment of compensation have been come up in this batch of appeal. Para 3 also, I'm just taking the facts. Para 3, placitum E, my lord.
This is, you are placing it only for order explanation for section 11.
This is,
Only-
my lord,
only for
yes,
this part.
once a writ court, my lord, passed an order, that cannot be disturbed in a parallel proceedings by even the appellate court in the LA, under the LA Act. So that is the finding, my lord. So,
That's what it's in,
placitum E, my lord, possession of the land owned by the appellant comprising Kharsanaba so-and-so, Tehsil, along with the lands of the large number of villages that came under this road construction. Though the possession of the land was taken over from the landowners in December 868, no steps were taken to formally acquire the lands by issuing notification under Section 4 of the Land Acquisition Act, so-and-so. Having failed to secure the justice to get any compensation or even step taken, being taken by the government for acquiring the land for 17 years, a public interest litigation was filed. The state of Himachal Pradesh failed to justify any valid reason for not taking steps to get the land acquired, for not paying any compensation to the landowners. Finding grievance of the writ petitioner to be genuine, the High Court, by the order dated, directed the respondents to complete the acquisition proceeding within a time frame. Further directed them to pay the writ petitioner's interest 12% per annum from the date of taking over possession in the date of payment of interim compensation and their final compensation. If there was enhancement, it was observed that the aforesaid interest payable was in the nature of equitable compensation, and such interest shall be in addition to the compensation, solitium interest at the statutory rate, which would be paid to the writ petitioners under the law, whether awarded by the collector or enhanced by the court, and such interest shall not be taken into consideration in any proceedings under the Act while awarding statutory compensation. The division bench gave the following directions. So it is over and above the statutory interest, solitium, everything. Now, my lord, this was interfered with when the matter came up before the High Court under the Act in an appeal. Now, the finding now, because that order of LA appeal was challenged before the Supreme Court. Now, the finding is at para 14 onwards. 1-4. Page 200. So this was a direction by writ court outside the ambit of the Land Acquisition Act, saying that this is over and above whatever is they are entitled to because of the delay.
This question was intriguing us since yesterday. My brother took the trouble to read all this and find out. Page 330, the amount was not deposited before Supreme Court. It was deposited before the Deputy Commissioner.
Yes. Here, my lord, it was deposited here.
Ninety-two. Where is the order of this court dated 16/6/2022 in WBC 190 and 211.
Yeah. It's 16/6 in 211 read petition.
16/6 is in the content.
Content.
15/6.
15/6.
Fifty? No, this is 16/6. 15/6.
Lordship, it is page 226 of the paper book. 226.
नहीं. No, I don't think that's there.
It's 61 of your comparison with the
ये order.
more handy.
Okay. This order, no?
No, that is 8/6.
No, this is 8/6.
Lordship, it is 226.
226. 226. It's really, yeah. Uh-huh. Yeah.
And Mr. Khattak, against this, did you file a writ appeal? Against 15/6, or you went directly to the Supreme Court?
15/6.
This 15/6/2022, page 228,
Order is the Supreme Court order.
226 to 228. This 228 Was any writ appeal preferred?
है मेरे पास अभी.
The Supreme Court order,
No, my lord.
the heading mentions arising out of.
WPC.
हाँ.
Arising out
It
of.
is two orders, impugned final order dated 15/6/2022. Writ appeal 2/11/2022 and 16/6/2022. In CC contempt petition.
It is writ petition.
The two
WPC.
orders.
Writ petition number 211, my lord.
So that means.
This, the top
that means-
mentions this. These are the two, at the top, it mentions arising out of.
WPC.
My lord, next page is the follow-up action of.
Mr. Kato,
My lord.
you see. This is okay.
Mr. Kato, one thing which has just come to our notice.
My lord.
You had filed this 211 before this court.
Correct, my lord.
This court, on noticing the facts, said something that this is the premises it is. Earlier proceedings were also noticed and it said nothing doing. Next day, in the contempt matter, there is an order passed. Page 57, 61. So and so, so and so, so and so. Your submissions have also been wrong. That there is a willful violation enabling so and so made that you will make a deposit before the deputy commissioner, right?
My lord.
That was not complied with. Now, against these two orders, you went up to the Supreme Court. Supreme Court said, deposit the amount. You deposited the amount.
Correct.
But why did you not pursue with that matter? Because by depositing the amount and saying that it has become infructuous, that has given a seal of approval to the earlier orders of this court. Supreme Court, right, wrong. Now, how can we come in?
My lord, as I pointed out,
Another.
my lord, my lord, make submission in the way. My lord, initially there was a directions of this honorable court to
Okay,
defer.
we'll just have Mr. Vishwaso. Yes, Mr. Vishwaso. On this, what do you have to say? No, I'm not on that. Now the matter has traveled to the Supreme Court. What would be the effect of this order?
Once the payment is deposited, so the compliance of the order has been done. Supreme Court, when Supreme Court says it is infructuous, they should have pursued, saying that it is not infructuous, because they have this ground should have been raised before the Supreme Court. So why it is not? Since they have not pursued, again, this is again a part of they should have done it, and they come back and file an appeal. Read appeal here, instead of agitating those issues, which they have taken it. All the
Writ appeal withdrawn.
Yes, they withdrawn. They did not pursue that. Even in the SLP, the grounds are identical. Identical grounds.
In the writ appeal, which order is under challenge?
In the writ appeal without, the impugned order is 8/9/2020. It's a single judge order in the writ appeal.
My lord, my annexure 21, my lord.
When the court was.
Page 318, my lord.
8/9/22 means the final order in 211. No, that is in this writ petition.
Yes.
Now, earlier after,
7/11/2009. That is the first single judge.
no, after they came back from the Supreme Court, matter was disposed of as infructuous. Did they file any writ appeal or they contested 211?
So before the SLP was said infractuous, the single judge order already came. The rate appeal were dismissed. Sorry, the rate petitions were dismissed by 8/9/2022.
No.
Can you see the SLP order date
SLP order is
is not
21-23.
so
By the time the 211 was also decided.
decided. Grounds are identical for the SLP.
There's nothing more you have to add.
Judgments on the-
We can give a list of dates with the index and the judgments and relevance.
And paragraphs.
So, those are only on the point, once that finally is okay, we cannot be reopened again and again. And one judgment specifically on their application, which says the government and the requiring body after the proceedings is over cannot come in 226 for reducing the amount. They have to proceed under the land.
37.
That is procedure, not maintained.
No, that was a judgment under 1894 Act.
Correct.
So because 1894 has a remedy. 1894 has a remedy, but this 2013 does not have a remedy. Therefore, one cannot be remediless. So therefore, writ petition in the writ court cannot say that you won't be able to come here. So otherwise, then the only determination becomes a final determination.
So probably because that's the safeguard which was inbuilt in the provision, because that whatever it is decided by the BN, who is part of the government, that is the threshold. They cannot reduce it. They cannot challenge it and reduce it. There can be an upward revision. The requiring body in the government cannot say in court and say, "Hey, further we bring it down."
That was an utopian what you call thought process, that what would happen would always be correct.
There's a lot of inbuilt,
Here we have very good and honest people where mistakes can be purchased.
We'll not go into that.
You have not understood the purport of what my lord is saying. Good and honest people, where mistakes can be purchased.
Right. And that,
This is the terminology used by Supreme Court of India in whatever judgment.
okay, all right,
Mistakes at times are purchased.
okay.
Therefore,
I will give a list of judgments along with the paragraphs. I will just place it on record. Yes.
Just a handwritten note will do.
Very
Don't
well.
not type it, just give the citations and then give the paragraphs, that's all.
Very well.
Give the judgment.
Very well.
Only one thing to clarify, my lord. After the judgment rendered in 2019, my lord, by the single judge, my lord, we filed a contempt petition 4 of 2020, my lord. Yes. Pendency. Yeah.
That order, which they went up,
Yeah.
according.
Yes, yes. Pendency of that, my lord, contempt petition, my lord.
Contempt of Courts Act. Contempt of Courts Act.
Hello. Once we have filed a contempt petition, my lord, in order to avoid my words may not be correct, my lord. In order to avoid that contempt application, my lord, they filed a writ petition, writ appeal before the, my lord, division bench, my lord. In the writ appeal, my lord, we are representing respondents 6, 7, and 8, my lord. Well, pendency of the contempt petition 4 of 2020, my lord, they filed a writ appeal, my lord, against the judgment of the learned single judge, my lord. Writ appeal 196 of 2021, my lord. My lord, we are representing the respondent number 6, 7, 8, and 9 concerning with the only MIPI community land, my lord, in the acquisition as well as for the award, my lord. In 196, my lord, they have challenged.
But factually, it appears that once a contempt was filed and an order was passed, they went to Supreme Court first.
Yeah.
Writ appeal, I think, came later on.
No, my lord. Pendency of the, my lord, contempt petition, my lord, orders were passed later on, my lord. Pendency of the contempt petition, my lord, they filed a writ appeal, my lord.
Which one?
196
196.
of 2021, my lord. My lord, against the, my lord, the lane acquisition in regards to MIPI village only, my lord. Page 36 will kindly see, my lord, the writ appeal, my lord. Of my compilation, my lord.
पेंडेंसी के बाद नहीं बनाया कंटेम्प्ट बाद नहीं बनाया
Yes.
My lord, in the writ appeal, my lord, the only challenge against the, my lord, land acquisition in respect of the MIPI village, my lord. Kindly see page 36, my lord. The party is, my lord. Because, my lord, it's important because I will come to that, my lord. Subsequent, my lord, appeal was against, also against this, my lord, the respondents, my lord, same respondent, my lord, the second writ appeal, my lord. My lord, this was, my lord, just has already gone the order of the division bench, my lord. May my lord read again, my lord, page 37, my lord. Paragraph third onward, my lord.
Mr. Biswas, you and Mr. Saike will have to give us in your list of dates which you have given, you have to also incorporate the orders which were under challenge in this writ petitions
Very
and writ appeals.
we'll create
Because otherwise, what's happening, we are missing link.
yes we'll do that
What went to Supreme Court of India, which order, against which order the appeal was filed.
correct
So
Correct.
we have, there's
we'll
some
give
link which is missing.
written note we'll give along with the orders Supreme Court orders will erect that so that
And the, my lord, LA
Because-
appeal was
because
also
this-
filed.
These facts about the
no.
writ appeal
Because
196
it's
being filed
important, my lord.
against order of so and so. We are missing a link.
correct.
Every time we have to open
After
the file.
closure
and we are not
of
finding
the,
it.
my
we'll
lord,
give it
writ
one place
appeal-
one note one place everything will be there
Huh.
all the orders
Huh.
Well, after closure of the 196 writ appeal, my lord, they filed, my lord, LA appeal against that BP land only, my lord.
That was dismissed.
That was dismissed, my lord. And thereafter, my lord, after dismissal, my lord, they have again filed a writ appeal, my lord, whereby, my lord, again, we are also made a party in that writ appeal, my lord. Those writ appeal were already disposed of, my lord, the 196, my lord. After disposal of the, my lord, writ appeal, they filed LA appeal. And again, after dismissal of the LA appeal, my lord, they have again filed a writ appeal, wherein again we have been made as a party.
This
my
part we understand,
Right.
but what we are missing is that link to the orders, which which contempt, which
Right,
order
right,
is the order against which contempt is alleged, which is the order against which appeal is filed, which is the order against which a writ petition came, because we are missing that link again.
My lord, I will give the link, my lord.
So both of you sit together and give us one comparison to be better.
My lord.
Don't give two, give one.
Both of you,
Whatever input you have, you can give it to Mr. Biswas.
My lord, because we have little difference, my lord, in some dates, my lord. So we will give individually, my lord, in respect of other respondents, my lord.
okay.
All right.
Because facts we are otherwise conversant, but we are missing, what is missing is that link. Every order, we have to find it again.
In the writ appeals and the LA appeal, my lord, there is something different, my lord.
Even that contempt, make a link
My-
to that
my-
order against which contempt is alleged, when the contempt was closed or otherwise.
Yeah.
Just
Okay.
give that link.
Contempt proceedings closed.
Close, my lord.
That order is on record.
Yes, my lord. And I have annexed that order also, my lord.
in your compilation.
Yeah, in my calculation.
Just give a link with those cases
Right,
and
right,
the
right.
appeals, so that it's easier for us to
Problem.
understand your submissions.
May I submit, Your Lordship?
Yeah.
Yesterday also, my lord, it was my submission before your lordship was, my lord, to, my lord, understand the factual and the background. My lord, the details of the background is required to be heard first, my lord. It was my submission, my lord.
You see,
It's because-
there starts the confusion.
My lord.
The reason being, for some reason, which their lordship may have understood more better. Against the interlocutory orders also, the appeals were entertained. Against the contempt orders, the SLPs were admitted. So that is normally not heard of. Because the appeal would lie only when there is a punishment. Even there not being a punishment order, the SLPs were admitted. There lies a confusion because when we are exercising our jurisdiction, whether the jurisdiction we are examining, also the determination we are making, touches upon anything which is already decided by the Supreme Court of India. That is where the problem is. That's why we are asking so many things about the Supreme Court order and the connectivity. Because the Supreme Court in its order says that matters become infructuous. What is the connotation of that order? How it will have a bearing with this matters?
Precisely.
You filed multiple appeals, even an LA appeal, and then we because of the lack of connectivity to these orders, we are missing that link. Although we are understanding your argument, but we are missing the link. So every time we have to open the file and then find out which order is which order has been taken up in appeal, which order has been taken up before the Supreme Court in SLP. That's why we are finding it out from the front page of the order of the Supreme Court that which order was actually challenged before the Supreme Court. So therefore, you understand our predicament because there's so much of bundle of facts here. You can also give your list of dates to just do connectivity, not the
I'm sorry, my lord.
not the write-up of the argument, but only the connectivity, which order has gone to appeal, so that you understand it very with clarity.
My lord, in brief, my lord, the first, my lord, the round of writ petition was filed by, my lord, some of the writ petitioners, my lord. In that writ petitions, my lord, this honorable court has given a directions to the deputy commissioner to determine as to whether this land belongs to a community land or the government land, my lord. Once his lordship has already observed, and once it is established that it is a government land, my lord, the question of the my lord acquisition process is, my lord, it does not arise, my lord.
No,
One
you
thing.
see, Mr. Kato, you see, we barely ask questions. We are not formulating our. It's only a thought process. We are exchanging. What you call.
Just I'm referring the my lord observation.
We are just like pendulum.
My lord.
We may tilt in the left side, but we may come back on the right side. Now you see, we'll ask you a question. When there's a land acquisition proceeding going on, there's a presumption that the government will not acquire its own land. Correct? So therefore, although we yesterday asked question to you as to whether the determination of whether the land is a government land or a private land or the community land to be determined, the presumption is in favor of the government, saying that the government would not acquire its own land. That is prohibited under the Land Acquisition Act. At least 1894, there is a decision that the government cannot acquire its own land. Now, if we take that into presumption, then there are two presumptions coming in again. Number one, that the land is not a government land. And number two, taking aid of section 114 illustration E, all judicial and official acts are duly performed. So therefore, there's a presumption for performance in favor of the government because the government acquires land which should not be a government land. Correct. So there goes one part, which is a response to the question we put yesterday.
Right.
Now the there's a second part to it. You see, we will show you, we put your question. Now you see, the point which we are making that about illustration E of section 114 of the Evidence Act, that all judicial and official acts are duly performed, thoroughly washed away with that. What is that advertisement? Daag achhe hain. What is that detergent? Surf Excel or something. Daag achhe hain. You remember that detergent advertisement? Now the circle officer comes and said that it's not duly performed. Correct.
Man.
Now, not duly performed is something which is not agitated by the Union of India. It's a state government stand taking that it's not there. But nonetheless, land acquisition proceedings, what you call the notification has come into record. Now that land acquisition notification was not under challenge by the Union of India. Therefore, the point which was pressed by Mr. Biswas is that once there's a land acquisition proceedings, the acquiring authority or the requiring authority, they can't disown saying that we don't need this land or we don't want that land. Those things are past because there's a presumption that all preliminaries were done prior to that notification of the land acquisition proceedings being published. Correct. Therefore, point number one is that your willingness is something is not required to be examined at all. Whether you need a land, you don't need a land. There's something that the read court can't determine. Because the challenge is, there's no challenge to the acquisition proceedings. Now, you see, yesterday we also posed a question for you to respond, both of you to respond, is that the impact assessment required under the 2013 Act was never required to be done because of the fact that since 1950 or 59, the Assam Rifles is in possession of the land. Therefore, social impact is something which is not required to be done. But there is a fact that there's nothing is placed before us to show that there was a waiver of the social impact assessment which is required under the 2013 Act. Now, the state government does not do that, you do not challenge it. Therefore, principle of waiver will it apply? Correct. It was never under challenge. Till date, it's not under challenge, except for the question of the court, it's never under challenge. Now, the last point is that once in compliance with the order of the Supreme Court of India, you deposit money without any protest, end of the matter. You can't raise anything because once the order is complied with, there's nothing to be challenged and that challenge cannot be reopened because by making payment, you have complied with the requirement of the land acquisition notification to make payment of compensation. So whatever we are deliberating since yesterday is only an academic discussion. We don't find anything here for which this repetition will be entertained despite all the orders passed from this court, from the learned single judge up to the Supreme Court of India. Once you, it's end of the matter. Finally, it is attached because there are many authorities on the point that once you comply with the order, then there cannot be a challenge.
So,
Malad, to that, Malad, the points regarding the Malad,
Let's just take a short break and come back.
Malad. While agreeing to Malad, the proposition arrived by your lordship, that apart, Malad, may I make submissions and in the Malad, the present appeal, that how this has been Malad, the initiated and Malad, the very fact of the Malad, the filing of the Malad, the writ petitions Malad as well, Malad. Malad, admittedly, because of the ignorance on the part of the Malad, the department as well, Malad, this has not been Malad taken Malad in the right forum, Malad. And as well as the order of the judicial, Malad, altogether we were in the Malad, the wrong forum for altogether, Malad. Therefore, Malad, the delay losses has been arised. Malad,
There's a one-liner. There's a one-liner to it. We were just discussing. Too many cooks. You may end it yourself.
Malad. Now, Malad, today
that
this
submission of yours will not sustain because even when you withdrew the writ appeals, it was for approaching the appropriate forum.
appropriate forum, Malad.
And if you have not understood the appropriate forum after 3-4 rounds of litigation, how can this court come to you?
Malad, exactly, Malad. I'll come to that point, Malad. Therefore, Malad, may I take your lordships to the annexures 17 of my writ appeal, Malad, 224, wherein, Malad, I was granted the liberty to file the appropriate applications before the appropriate forum, Malad. Now the question is, Malad, where is the appropriate forum? I'm asking myself on the Malad, several issues regarding the Malad, the forum. Now, Malad, it has in one aspect, Malad, it has been already pointed out that we have to prepare the Malad, the appeal under the Malad 74. 74 is not Malad amenable to us, Malad. And again, Malad, the 69 appeal to the High Court, 70 Malad, again
64, 69, 74, not available.
Again, Malad, reference, Malad. Reference, Malad. Reference is also not possible, Malad. Is not permissible, I'm sorry. And therefore, Malad, may I take the lordships to the section 63. Where is the remedy only, Malad? Section 63 of the Right of Air 2013 Act, Malad. Section 63, Malad, may I read, Malad, for a moment, Malad. Section 63, what it, Malad, it says, no civil court other than the High Court under Article 226 or Article 227 of the Constitution or the Supreme Court shall have jurisdictions to entertain any disputes relating to land acquisition in respect of which the collector or the authority is empowered by or under this act, and no injunction shall be granted by any court in respect of any such matter. Malad, this specifically bars the, in case of land dispute, in the Malad, the acquisition process, it is the only Malad, the section which Malad, given the remedy to the Malad, the person and the requiring authorities, Malad, requiring body specifically. So therefore, Malad, on the last occasion, Malad, when the read proceedings in 211 was Malad before the on single bench, that query was specifically forced to me, Malad. And in that, Malad, the reply, Lordship has already seen that in that reply, that was the Malad, our Malad contention is Malad, not only the award, it is notification, Malad. Notification has ought to have been issued by the respondent authorities in consultations with the Malad, the requiring body. Requiring body is the Malad, the ultimate authorities to Malad, the Malad, in Malad, the acquisition process has to be initiated. Malad, admittedly, This land, fish of land has been taken over by the ITBP in the year
Just come to
2020.
that section, come to that section again, the power of the High Court, where is that?
Madam, section
63.
63, madam. I was reading section 63, madam, of the right to fair. It is specifically in respect of any land dispute in acquisition process, madam. Relating to land acquisition.
Just tell us, according to you, what is the scheme of land acquisition? How does it process from the initial scratch to the payment of compensation and the land acquisition? What is the steps?
Malad, to make, Malad, as per my limited understanding of the law, Malad, Malad, there is silence about it when the possession is already under the Malad, the authorities, Malad. So therefore, only Malad, to my Malad understandings of the facts is, Malad, to that aspect, Malad, on the assessment can be done, Malad, not the acquisition. Acquisition is something different. It has to be Malad culminated from the Malad initiated from the Malad, section 11 or section 440. Malad, and
I
it
do
has
not
to be.
understand that. You see, let us say you are a tenant in respect of a particular land. You are a tenant, you are occupying it. You are not paying rent.
Malad.
Now, in the meantime, the landlord offers you to purchase the land and you want to purchase it. Can there be a bar in purchasing the land in which you are tenant not paying rent? No. So therefore, irrespective of whether you are in occupation of the land, a land acquisition process can still be undertaken. You are not challenging that process.
Malad, I'm sorry, Malad, I have not brought that,
No,
the notification issued by the state
The
government.
notification has not been challenged by you.
Of late, Malad, we challenged in the border rate petitions, Malad.
Which
Ek-
petition?
211 as well as the 190, Malad. Initial,
That we know the result.
Malad.
We know the result of that.
That rate petition, basically, Malad, we impugn the Malad, the impugn notification issued by the state respondent as well as the impugn award passed by the Malad landed deputy commissioner, Malad. That was the only Malad, the impugn in the border rate proceeding. Therefore, Malad, may I take your lordship for the rate petition, Malad? We are on rate appeal 141. It is in connections to 211 rate petition, Malad.
Writ
Of
petition is,
2022.
writ petition is not here.
I'm sorry, Malad, I have not enclosed the, Malad, it is in separate 211 of the 222, 2022. And lordship has already very first paragraph 1, Malad, page 8 of my rate petition.
Where is that section 11 notification? It was on record.
Malad, it is in, if lordship is having the Malad, the rate appeal,
That is 281.
Malad. And this is the third notification issued by the state respondent, Malad. I'll come to the first and the second one, Malad.
24.
24 for 18.
Wait a minute. Yeah. Oh. Is well challenged by the one. Okay.
Malad.
Mr. Khato, you can give a small write-up along with your dates. Your projection of the dates. They'll give their respective projection. You give your projection. Give it by.
You see, we'll tell you, there are, we have already narrated our thought process. We have posed you questions based on the deliberations made yesterday. You see, one of the questions asked even now was that once the award is paid by depositing it before the district deputy commissioner, how can you challenge the notification of 2018? Correct. Once you comply with the notification, you make the payment of compensation. Then can you turn back and challenge the notification? That's the first question we asked you. So you see, anything else which you argue will not fall in place, will not be following it. The court query is not for nothing. And therefore, when you have formatted the court query, you'll have to respond to it. You may postpone it for some time, but you'll have to respond to it. Otherwise, things don't fall in place. You make the payment and then say, no, I challenge that. So that money can't be returned back. Let us say now today you challenge it, we uphold the challenge. Then what happens? Rafiq Masih says that if it is not for the fault of the person that you make payment to him, you can't ask him to refund it for grade 3 and grade 4 employees. We don't know the status of the citizens to whom the land acquisition payment has been made. You did not lodge a protest. The court does not know, competent court has ordered that this money will be kept in safe deposit or fixed deposit, so that interest earned and the money can be returned back to the government. That was never a stand of the Union of India. Now, how do we accept your challenge? What can you do with that notification? It has been acted upon. After you see, it's just like hiring a car from Naharlagun to go to Guwahati. Having reached Guwahati, you said, no, I have made a mistake. I have to go to Tinsukia. I came here wrongly, so no payment. Now you take back to Tinsukia, and then we'll make payment from Naharlagun to Tinsukia. It's almost similar to something like that. My examples are always absurd. But this is just an example. You can't come to Guwahati land and then say, no, mistake. This is Guwahati. I thought it was Tinsukia. Now refund me the money. Can't do that.
Well, my understanding of the fact is, true, admittedly, that the factual position is correct, admittedly, here in the other aspect also, that amenable to the under Article 226 is, to my understanding, is because is still intact. As because in that the writ, the SLP.
There was no reservation when you undertook before the Supreme Court directed you to make deposit.
Supreme Court, I'm leading to the filing of that SLP was basically for the personal appearance.
No, we don't know about those things. Why did you file it? It's not a query.
When the
101 reasons why advocate will file a case. So we are not asking the lawyer to explain why it was filed. Our query is that when the Supreme Court gave you a direction that you deposit money, you did not lodge a protest before Supreme Court of India that we are challenging it. Therefore, this money we are ordered may not be dispersed. So therefore, it is in compliance with the award. Supreme Court, when asked you to deposit, that means they are confirming the award. Now let us take an example. You see, you file a money suit, 100 rupees of money suit you file. You win a decree of 100 rupees. And you are required to make the deposit in execution. You come in appeal and you file an application under Order 41 Rule 5, asking for the court to deposit it under protest so that this money is not is a deposit for prevention of the execution, and therefore the challenge to that 100 rupees is still there. You are not depositing the money. It is only for the execution that you give a deposit before the court, and that deposit is dependent on the orders passed, whether it will be given, and then we say that you give a money bond, give 100 rupees to the decree holder, give a money bond. If the appeal is decided in favor of the appellant, you have to deposit that 100 rupee, refund the 100 rupees again. That's how we understand. That was not done in this case. Therefore, please tell us, having complied with this is the third time we are asking the same question. Having complied with the award, can it be amenable to determination by this division bench?
Even before the single judge, the split was active. But this is
Well,
fairly submitted.
My understanding is,
You have heard my brother? You have heard my brother? No.
no, my lord.
You see, even if we take up this issue in the writ appeal, this matter was not urged before the learned single judge, and therefore we are prevented to take up this matter as an original determination in the division bench. The matter having not been urged before the learned single judge creates an embargo to this division bench to take up the matter as an original determination.
Correct. That is the manner, when the matter was withdrawn on infractious manner, that was the even instructions to the authorities concerned for the manner to make another remedial, judicial remedial to revive the order manner. Exactly precisely what was happened in the matter. The contempt petition was pending before that relevant point of time. And that in this honorable court, in that contempt proceedings, by order, if the amount is not deposited within such time, stipulated period, the personal appearance of the officer concerned was called for. And
No, courts are not powerless. You see, what is the point in filing an appeal? If you don't pray for a remedy for making protest payment, so that you are what you call, you see, there's in the contempt, there's a requirement that you must purge off your contempt, then you will be heard. So when we are ordering you to do something in deference to the court order to escape punishment, so that itself, the court is well empowered to say that this amount which is being deposited shall be kept in safe custody or fixed deposit and not be released. So therefore, you see, you can purge off your contempt. Does not mean that the purging of the contempt would necessarily mean that you pay the money to the beneficiaries.
that relevant point of time, these two writ petitions were in Siasin Malad. Thereafter, it has been closed. It is the very fact of the case, that after depositing of the amount,
So that's why you give your return dates. Actually, you have heard.
As per your projection.
As per your position, give us list of dates.
Another connected writ matter. Here, my lord, same parties, same prayer, same grounds matter. So it's not maintainable matter.
You cannot tell us because you see, it's becoming difficult for us to follow it.
It's item 7.
It's on record.
Yes.
Item 7. Item 7. Same impugned order.
in that matter, may I submit,
Yes.
subject to the outcome of this first item, item number 7, that will automatically the
No, my lord.
hearing. So therefore, at this stage, I'm not pressing on that,
Same order has been challenged.
Yes.
And the same ground, my lord.
Respondents also say.
Same. So this is the impugned order. It's all along, my lord, your lordship will see it is always two writ appeal, 2 writ petitions like that. It is proceeded.
You people are too powerful. You have created a lot of problem for the Union of India.
My lord, the only merit in this case is the other side is the Union of India, my lord. That's why they have proceeded so far.
And we'll have to burn the midnight oil.
We will file the written notes, my lord.
No,
within-
don't find an argumentative.
No. Only
We are not
facts.
taking
Only
argumentative
facts.
Facts,
Only
as my
facts.
lord has said, facts along with the
List of
connecting orders.
Orders.
Want the connecting orders because you're finding it difficult to follow.
We will place it. Within 2 days, we'll place it, no? 2-3 days. Or
You can take the what you call the email number of the courtmaster and you can mail it to.
we'll do that.
Make it by Friday.
Right.
handwritten list of judgments.
So this also, this is only the judgments and
Okay,
the.
that no problem.
That.
By Friday, if you
Right,
can give
by
it
Friday.
physically, give it.
Ah.
If you can't give it physically, mail it to the
Very-
master.
We'll do that.
Mr. Kato, you also.
My lord.
Mr. Soika.
Grateful, my lord, for a patient hearing. I'm grateful.
No, we are not heard patiently. We are stopping you from arguing.
For lengthy hearing. For lengthy.
The
The facts were very
the
tough. That's why.
submissions of Mr. M. Katul and DSGI. For the appellant. Mr. Seeley. For the appellants, Chief Secretary, you will be appearing, Mr.
Chief Secretary.
You'll be there. Mr. Stapil Lanet, City Government Advocate appearing for respondent number 1, Mr. D. Kamdu. Standing counsel for respondent number, oh, sorry, you is for 1 and 3. Mr. D. Kamdu is for respondent number 2.
For respondent number 2, madam.
For 3 to, sorry, from 4 to
4, 5, 6, I am appearing.
4, 5, and 6.
6, yes.
Mr. Mr. Biswas, your first
Your
name?
first name?
Rituraj Biswas.
Yes, R. Biswas, council of respondents. 4, 5, and
6.
4, 5, and
4,
6.
5, 6, yes.
And Mr. You're appearing
Yes.
for?
4, 5, 7.
Our wakalat number, ha.
Sir, 4, 5. Who's for others?
7, 7, 8,
Okay.
9, 10.
7 to 10, Mr. Saikia. I'm going to come to it. Full stop. The learned counsel for all sides are permitted to file their list of dates with the narration of various orders against which writ appeal or SLP was filed. Along with the page, the index of pages where the said orders are available. Full stop. The learned counsel are permitted to either file it physically or through email to the court master by Friday.
Right.
Fridays.
Email ID.
Friday is 24. Subject to filing of the list of dates within time, the judgment is reserved. Then this second item, 42, as you say, so it has been jointly submitted by the learned counsel for the parties that the determination of this writ appeal would be dependent on the determination of WA 41 AP of 2022. Stop. The submissions made in the said WA 41 AP of 2022 is adopted for this writ appeal also.
Yes.
Stop. Next. In the connected WA 41 AP of 2022, the learned counsel for the appearing parties are permitted to file a list of dates by 24/5/2024, subject to filing of the list of dates, judgment is reserved.
Very good. Grateful.
Mr. Biswas, just what do you call you, since your appearance look familiar, may I ask you, you are related to Justice Biswas?
Yes. Yes. Yes.
Your name clicked.
Your appearance is quite
Very familiar. He's keeping fine.
He's. Thank you.
Ahmed, judgment is reasonable.
But Mr. Khato, you tried really very hard. You kept us, you delayed this whole thing. It's only because of you. Good.
Deeply applauded.
May I please, Your Lordship? Jail, this is a jail appeal. Conviction.
Lordship. Anyways, the sentence has been suspended. The sentence has been suspended, so I'm in no hurry.
To give defense witness in
Yes,
matter.
yes.
Where is that?
That is, Lordship,
Page
Page number 61, Your Lordship, 6,
paper book.
48, paper book, yes.
48.
it's also written 61, so.
It's the accused is the person.
Lordship, Exhibit 2.
24, Your Lordship, page number 24.
Is it list of the bamboo?
Serial list, Lordship, at page number 15, Your Lordship.
15.
Yes.
One meter. Bamboo. There was a finding somewhere that there was no blood stain in the kitchen. Where is that?
There is no
Somebody-
blood stain.
there's
It's in the,
witness- Some witness said,
it's in the The position of the IO.
Where is that page?
The position.
41, Your Lordship.
Huh?
41.
41.
IO says two things. At page 42.
I'm more
that,
interested in that. No blood was found. That part.
that part, Lordship, that is at page 43.
42 said I found blood scattered on the place of occurrence.
Yes, after
But
saying that,
somebody said there was no blood.
same Lordship, page 43, same witness has said, I believe the accused had cleaned the blood-stained floor before my arrival.
Pardon me.
In the last line, page 43.
Uh,
Also at page 42, he says he did not send the bamboo stick and dowel because he did not find any blood in these articles.
We're taking it up on Monday.
Lordship.
What is represented? Due to positive time matter could not be taken up today, based on the date of Monday.
Your Lordship. Your Lordship, earlier in item number 5, by mistake, I have submitted that I will not file affidavit of opposition, whereas I will file affidavit of opposition on behalf of respondent number 13.
Item 5, you say letter on Mr.
J. Karbak.
J.
Karbak.
Learned Counsel for respondent number
13.
Submits that that he had mistakenly stated that he would not, that the respondent number 13 would not be filing an affidavit. So however, he has instructions that the respondent number 13 will file an affidavit. So
And
can
I
it be
have
done?
instruction to
One
file
try to
Wakalatnama.
listing.
I will file Wakalatnama. Obliged.
Tuesday, we already have a matter fixed. Okay, we
Well,
still see on that day. Okay.
Yes, sir.
Okay, both sides are duly represented. On the prayer made by Mr. T.T. Rara, counsel for the appellant. Matter stands adjourned today, list on Tuesday.
Wednesday.
Wednesday in that case, ma'am.
Wednesday in that case. Grateful.
Let it be Tuesday, we'll see.
Yes, yes.
If not, then.
Interim is there. Interim order. Interim.
Interim order passed to this, extended till the next date of listing.
Grateful.
May it please your Lordship. Item number 22. Well, in this contempt petition, we have got an affidavit in opposition filed by the sole respondent. We'd like to file a detailed reply. Well, I want that Lordship may fix it on the 18th, where a connected matter today was fixed, as per Lordship's convenience. Item
Okay.
number 22.
How much time you need?
Well, if your Lordship can give it on the 18th, there's a connected matter today, PIL, which was fixed on 18th of June.
Okay, both sides are represented.
My lord, I'm appearing for that side, the contempt order.
Both sides are represented. On the prayer made by Mr. D.K. Das, counsel for the petitioner, who is appearing through video conferencing. Matter stands adjourned to enable him to file affidavit in reply in the matter. agreed to by both sides list on
18th of 18th
2024. Okay.
of life.
May it please, your lordship. May it please, your lordship, in connection with item number 14, my lord, I may be allowed to bring call for record of writ petition, writ appeal W8 of 24, my lord.
Records.
Yeah, Lordship. Lordship, I beg to mention item number 8, Lordship. This matter may be taken up after 2 weeks, Lordship.
8.
Yes, Lordship. I am for the petitioner, Lordship.
Okay. List after 2 weeks as paid for by the counsel for the petitioner.
Right, Lordship.
My lord, may I mention item number 26 on behalf of MS Sharma? So kindly list this matter on Monday, this coming Monday.
Item
26,
26.
yes, on behalf of MS Sharma.
Okay. You have taken consent of the other side?
Yes,
Okay. With consent of the other side. Prayer for adjournment is made on behalf of the counsel for the petitioner. Matter stands adjourned today. List on, give it on Monday.
on Monday.
Okay.
Obligement.
Lordship, I beg to mention item number 9 and 11 on behalf of
Item
9 and 11 on behalf of L. Perme, Standing Counsel for Power Department.
9 and 11.
Yes, 9 and 11.
You are for
For
petitioner.
for on behalf of L. Perme, Standing Counsel Power Department.
Both
May I,
are
Lordship?
represented.
Lordship, item number 11, they are continuously taking last 2 occasions for filing a counter affidavit, Lordship, but not yet filed, Lordship. This time, Lordship, maybe last chance, Lordship.
9 and 11.
11, Lordship, item number 11, Lordship.
So he's making a prayer for 2 cases. So let me pass one by one. Item 9. Both sides are represented on the prayer made on behalf of Mr. L. Perme, Standing Counsel for the
Power Department.
Power Department. Madison's adjourned today. List after
3 weeks, Lordship. 3 weeks.
3 weeks. And in item 11, the next paragraph, the same thing in the item 11 also. The legal counsel for the petitioner submits that the respondents have been granted time twice to file affidavit in opposition. Stop. Accordingly, the Power Department shall ensure that the affidavit in opposition is positively filed within at least 1 day prior to the next date of listing. List after 3 weeks.
And Lordship, item number 19. And item number 19 also, Lordship.
Item
Item number 19.
18.
19. 1.
19.
Here also for L. Perme on behalf of Standing Counsel, Agriculture Department. For respondent.
Lordship, same issue, Lordship.
Okay. You say preparing for the Standing Counsel for Agriculture Department is taking time. Here also no affidavit
Lost.
filed. Okay, same order, affidavit not filed. Huh?
Lordship, either last chance.
You're not saying that.
Yeah.
You're making it clear. So it should file. Huh?
I will like
Agriculture Department should file affidavit within prior to next listing.
I beg to mention item number 25, madam, on behalf of Mr. A. Saring.
Both sides are represented on the prayer made by counsel for the petitioner. The matter is adjourned today. List after 2 weeks.
Right.
Okay.
May I please, madam? My lord, I beg to mention item number 5 and 7.
Item
Item number 5 and 7, man. In both the
Yes.
method, my
My lord, I am supposed to file affidavit in reply.
Which is represented. Matters is adjourned to enable the petitioner to file affidavit replying the matter. List after
After 2 weeks, my lord.
2 weeks.
Organized.
May I, Your Lordship, I beg to mention item number 17 on behalf of Pada. We are the respondent here. Mr. Pada is feeling unaware today, so matter may be adjourned.
No, here we'll have to see the record. Item 17.
Lordship, item number 17, Lordship, I am for petitioner, Lordship. And there have an interim order, Lordship, that may be continued, Lordship.
No, just a moment. Your prayer is on whose behalf?
Pada. He is the Standing Council of Tourism Department.
You see, if the tourism department is not filing an affidavit, we'll ask your officer to be present with all the relevant records.
Yes.
You've taken sufficient time to file affidavit.
Your Honor, Your Lordship, he is unwell, so.
No, he may be unwell,
Yes,
but the affidavit has to be filed.
yes.
From 22, it can't be unwell from 2022 till date.
We will file our affidavit, Your
No,
Lordship.
that's okay. But if you don't file, your officers will be present. Also, it's a representative. Prayer for adjournment is made by Miss
Talom.
S. Talom, learned counsel appearing on behalf of Mr. N. Pada, standing counsel for the tourism department, on the ground that he is unwell. Full stop. In this case, notice of motion was issued by order dated 23/9/2022. Until date, the affidavit of opposition is not filed. Full stop. The respondents are directed to file their affidavit in opposition positively 2 days prior to the next date of listing. Full stop. On their failure to file affidavit in opposition in the matter, the Secretary to the Government of Assam, Arunachal Pradesh, Tourism Department, within bracket, respondent number 1, the Director, Department of Tourism, within bracket, respondent number 2, and the Deputy Director, Department of Tourism, within bracket, respondent number 3, shall be personally present with all relevant records and be prepared to assist their standing counsel on the court query. Full stop. The personal appearance would not be required if affidavit is filed at least 2 days prior to the next date of listing. Next, list on your date after 3 weeks. Date 10/6/2024.
Lordship, interim may be continued, Lordship. Interim may be continued, Lordship.
Just a minute. Interim order passed to this and extended to the next date of listing. What is the interim order? Yes, for the government, who is there in this matter?
Lordship.
Who is appearing for the government? Item 17,
Yes.
you're there.
Yes.
What are your instructions from the Deputy Commissioner?
Lordship, we are here to receive our instruction.
Yes, you had the got her presence, your name,
Please, Sangeeta, Lordship.
the government advocate for
I'm
responsible
appearing on behalf of Kesan Wangmo.
on behalf of
Kesan Wangmo, she is the conducting counsel.
the government advocate. In this affidavit, you also write about respondent number 4. For personal appearance of Deputy Commissioner, East Siang District, with the back respondent number 4. Response also.
May I, Lordship? Lordship, I beg to mention item number 10, Lordship. Here also, I'm for the petitioner. Respondents have not yet filed their affidavit, Your Honor. Only respondent number 4 have filed the affidavit.
It's okay, they are not asking for time. Wait for your turn.
Then, Lordship, here I have to file my rejoinder.
Then you take your time. Why you are telling about others? They are not wanting to file it. Why do you are referring to others?
Lordship.
You want to proceed with your matter.
Lordship, I have to file my rejoinder, Lordship. The matter may be adjourned.
Rejoinder to what? If no affidavit is filed, what rejoinder you will file?
Respondent number 4 have only filed their.
They have filed it.
Yes. Rest 1, 2, 5, 1, 2, 3, 4,
Both
3
sides
and 5 have
presented.
not filed.
The only prayer made by counsel for the petitioner. List after 3 weeks was to enable them to file affidavit in reply to affidavit in opposition filed by respondent number 4.
4.
Right.
Obliged.
My lord, it is common order in respect of two individuals. So far as one is concerned, your lordship had passed the order yesterday. The other individual has come.
Same thing.
There were two individuals covered by the common order.
The yesterday's matter was petition number
197. 197.
197, same order. Yesterday, last same order, 197 of 2024. Mr. K.P. Kariwal, Senior Counsel, Mr. K. Saxena, Counsel for the petitioner, and Mr. Stapin, the government advocate appearing for all the respondents.
Yes.
Okay, same order, huh? Yesterday.
All.
Item number 2.
Madam, matter may be passed for the time being.
For time being.
Yes, madam.
Number 3.
May I please, your lordship? Here, the petitioner is the private limited company under the Venaya style. Indus Viva Health Science. So, as per direct selling rules 2021, the company has applied here in the state of Arunachal for the entity of the company here for doing business. So the NXR 12, my lord. NXR 12 is the representation. So representation is yet not disposed of. So this petition is filing for disposal of the.
But you are a direct selling agent. Your company is direct selling.
My lord.
You are a direct selling, what you call consumer company.
Yes.
So we can't protect you. You are this pyramid company. You are a pyramid company.
Yeah, this company is production company and direct selling. Company.
No, you are a pyramid company.
It's a registered company, my lord.
You have any document to show that the appropriate government or the any court has declared that the attachment made of your company's wealth of 66 crore was returned to you as a non-multi-level marketing company?
Yes.
Where is
Lordship.
that? Which page?
At Bangalore, it's a Bangalore-based company. In the Hyderabad, it was a writ petition was filed by the company and interim was granted.
No, 66 crore rupees was recently attached of your company as multi-level marketing scam. What is the decision of that? Is your selling, is your document by which you are selling products is on record?
No, the company is flourishing in
No,
Northeast.
no, you see, I am asking you a specific question. My question to you is there any document on record by virtue of which you are selling your products? Your marketing document,
Yes.
is it available on record? Because your company profile I checked up. Incidentally, this same matter was moved before the principal seat.
Yes. My lord.
And there, today I won't waste my time, but on that day I checked up in the internet. In the internet, it is available that you have about, I forgot, it is either 13 or 8 level of marketing, what you call profiles.
My lord.
Therefore, the money spent on the purchase of one product of yours, it gets the people, the executives above you,
Yes,
they all get a share.
My lord, this is drafted by another Guwahati-based advocate, so I have received
I understand.
some time may be given.
I understand.
Yes.
Because yours is a multi-level company, multi-level marketing company.
My lord.
That's why your document of marketing is not on record. Your today, in fact, I find that the website of your company.
My lord.
Last time when I pointed out, the website of your company itself is not on record. Now in the internet is not showing your company website. About 10 days back, the matter was moved before my bench in the principal seat on this uncomfortable question being asked. Now your website is no longer found in the internet. If you are a company and your profile is not available in the internet,
My lord, that is.
you check up in your mobile also. It's
I'll
not
have to
there.
go through my lord.
It's Mr. Nawam.
Some time may be given.
This is a place wall, my lord. So many fraud companies are coming up.
No, it's not that. It's a multi-level company, but they are showing the.
It's a multi-level
But I'll tell you, let me tell you, this company is a marketing level company, and
Yes.
one government attached about 66 crore rupees of their assets
My lord.
on the ground that it is a multi-level company. After
Yes.
this, the company is moved to various courts, including Hyderabad High Court, the High Court of Bangalore, and one more court. 3 courts have given them an order, and they are protected not to be harassed by the police for multi-level marketing. Now, in the last time when I visited the internet, their website was there. In the website, you will find that there was a slot for documents. You open up the document and you will find the marketing document there. In the marketing document, if you open up, then you will find that they're multi-layered marketing. This is a 13-layer marketing level marketing. So therefore, supposing you buy a product of 1 rupee, it will be divided within 13 of these marketing executives.
Yes.
8 or 13, I forgot. I have a very big memory. So this is what has happened. So that question was asked, and therefore this matter was.
That could be another record, man. Who knows?
And now it is being moved here.
Another interesting fact, my lord, may I just point it
Yes,
out,
yes,
my lord?
why not? Why not?
Well, how this thing can be happened? My lord, regulation is somewhere else and authorization is somewhere else. Madam, may I just point it out, my lord? So I doubt the documents which are annexed, the authenticity of the documents are also very doubtful, my lord.
No, documents are okay. We want
My lord,
for the time being.
May I take your lordship to page 27, my lord? This might surprise my brother also, my lord.
27.
How this can be happened, my lord? Page 27, this is letter of authorization.
27.
Yes, my lord. By this power, my lord, is before your lordship, my lord, the gentleman.
27, yes.
Has your lordship got it, my lord? Top line, your lordship find the date, my lord, 19/3/2023.
Yes.
This is authorization date, my lord. And see the resolution adopted by the board of director, my lord.
Yes.
In the meeting of the board of director, Indus Viva Health Science Private Limited held on 15 May 2023. How is possible, my lord?
Oh.
Prior to the regulation, they have already authorized him, my lord. Very interesting, my lord.
Correct, correct.
Anyway, my lord.
Oh, no, it's
And
okay.
another thing, my lord, the
Yes,
defective
okay,
copy
we'll
has been
note
served to me,
that.
my lord.
We'll note that.
Yes.
19.3.
Heard Mr. Uttam, Decca Learned Counsel for the petitioner. Stop. At the outset, Mr. R.S. Nawam, Learned Additional Advocate General, has for the state has questioned the maintainability of this writ petition by submitting that Annexure 1 to the writ petition is a letter of authorization dated 19/3/2023, wherein reference is made to the meeting of the Board of Directors held on 5/5/2023. Full stop. Apparently, and expressly, it appears that the document is manufactured document for the purpose of this.
Another document, Mala. Impugn order, Mala. This is addressed to the Manipur government, Mala, not to Arunachal government. The last page, Mala, page number 207, Mala. They have right now they have given the correct that correspondence. If your lordship see 207 to the Director Consumer Affairs Prudence Public Distribution Office, Singai Pro, Brazil, Imphal West, Imphal, Manipur. Mala, we have nothing to do with this Imphal Mala government, Mala. This is the impugn order, my lord. 207, my lord. Has your lordship got it?
No, this can't be impugned.
Well, yes, my lord. 332 this is the impugn order, which they have said, my lord, this should be solved.
No, they want to process the representation.
My lord,
Not
this representation is submitted to some other state government, my lord, not to Arunachal Pradesh, my lord.
Next para. Moreover,
This is also defective, my lord.
submitted that
now, of course, they have given me the correct one.
in prayer 1 of the writ petition, the petitioner is praying
I
for
don't find any
processing
acknowledgement. That is the
the
problem.
representation dated 3/3/2023 within bracket Annexure 12. Full stop. He has submitted that the said representation dated 3/3/2023 within bracket Annexure 12 is addressed to the Director, Consumer Affairs, Food and Public Distribution Office, Sangai Pro, SANGAIPROU, Bazaar, Imphal West, Imphal, Manipur. Full stop. It is submitted that the said office is outside the territorial jurisdiction of this of this court.
My lord, it's a technical mistake, but later on it was.
No, it's okay.
You better withdraw and file a fresh.
Accordingly,
So, yes,
the Learned Counsel
My
for the
lord.
petitioner.
I may be allowed to withdraw for filing a FRAP, which appropriate
According to the
annexes.
Learned Counsel, the petitioner prays for permitting him to withdraw this petition and to approach the court again.
Well,
Stop. The prayer is allowed. The matter is dismissed on withdrawal with liberty as paid for.
Hope that.
Can pass over for the timing as the council. Contemptible.
My lord, I'm referring to respondent number 5 and 6 for the first time. They were implemented later on, this 5 and 6. I am now appearing for them, lordship. I have the instruction to appear on their behalf.
Okay.
So since I do not have the copy of the contempt petition also, lordship, matter may be punished.
You want a copy of the contempt petition? You want a copy of the contempt petition?
Yes, lordship.
Give to him.
Lordship.
Heard Mr.
B type audio.
B type body Learned Counsel for the petitioner. Stop. Mr. D. Kambuk Learned Counsel appears for respondent number
5 and 6.
5 and 6 and prays for a copy of the contempt petition. The Learned Counsel for the petitioner shall provide a copy of the contempt petition, two copies of the contempt petition to the Learned Counsel appearing for respondent number 5 and 6.
Yes.
Within 2 days. Next paragraph.
Oh.
Mr. Tara, you are also there?
Yes, sir. I am from the NHIDC.
Mr. T. Tara, representing respondent number 5 is present. Next paragraph, list after.
Container number 5.
I've noted that.
Yeah, I'm fine.
How much time you need?
Right. No, I am fine. Well, I've just check out the contempt petition, IA, the petitioner has filed. In that IA lordship,
I think you will be 6 and 7.
I am appearing for
6 and 7.
as per this petition lordship.
It's very easy. You just remember who paid you the appearance fees.
I copy.
Mr. Kamlo,
Lordship.
just close your eyes and remember who paid you the appearance fees. Then you'll come to know who you'll be appearing.
I have just check out lordship. In their IA lordship for implement, they have. Yes, lordship. This is the IA number 42. In the IA number 42 that was filed in 2024. Both this is second, AK Singh was made as respondent number 5 as per this IA.
No, he's 6 and 7. 5 is already NHI DCL.
Then lordship is 6 and 7.
6 and 7.
But here in this IA lordship, it has been reflected
No,
as
it's okay.
5 and 6.
No.
No issue lordship,
6
6 and 7.
Make it
Yes.
6 and 7. And Mr. Tara for 5. On the prayer made by the council for respondent 6 and 7. List after 3 weeks, so as to enable them to file affidavit in opposition in the matter.
Yes, sir.
Next paragraph,
Much obliged.
the pendency of this contempt petition shall not be a bar for the compliance of the order of the court.
Yes. But this, the petitioner was suspended.
Just a moment.
Yeah.
Yes, if you have not passed a speaking order, we give you 7 days notice.
Notice.
We are issuing a short notice because
Matlab
if you have not-
basically
if
will
you
be
have not given a you have not reviewed the order, then Ajay Chaudhary will operate. Right, we are giving 7 days notice. Heard, Mr. T.T. Tawar and then counsel for the petitioner. And Mr.
Matlab, I'm for the respondent number 1 only, Matlab.
These are the 4 are 2 and 3.
2 and 3.
You have got 2 and 3.
Standing counsel. Are
The DJ for respondent number 1 and Mr. T.
Gadi.
Gadi, learned counsel for respondent number 2 and 3. The petitioner was charged with, who was arrested by the police on 25/9/2023 in connection with Itanagar Women Police, Itanagar WPS case number 93 of 2023 under section 376 IPC read with section 4 of the POCSO Act was suspended by order dated 29/9/2023. Full stop. The petitioner was released from custody on 7/2/2024. Full stop. The petitioner alleges that the, where is this 29/7?
18, page 18.
Page
18 and 19.
18,
Yes.
1/8. This is, date is wrong, 29/9.
29/9.
So he was So the petitioner projects that that there was no review of the order of suspension by more than 90 days of its passing. Full stop. Hence this writ petition. Full stop. As the issue notice returnable on give a 7 days returnable date after 7 days returnable on so and so requisite without requiring comma without requiring the petitioner to take steps as all the respondents are represented. Full stop. Extra copies of the writ petition be served on the learned CGC as to DSGI as well as to the learned counsel for respondent number 2 and 3 in the course of the day. Next paragraph. List on. Just before that, issue notice, including notice on the prayer for interim relief.
Grateful.
Matter may be passed over for time.
For the time being, okay.
Lordship, in this case, our affidavit is ready for swearing. Yeah. So,
By when you will file, Sri Ram?
Lordship,
By when you will be filing?
within a week, Lordship.
Hmm?
Within a week.
Within?
Within a week, Lordship.
Within a week. Okay. Both sides are represented. Mr. I. Ram, Leonard, government advocate. You are appearing as government advocate?
Lordship.
You are appearing as government advocate?
Yes. Yes. Only for-
Additional senior government advocate. Praised for and it's granted time to file affidavit in opposition in the matter. List on, give after 10 days. 29/5/23. Obliged. That's right. Yes.
Should be petitioners before your lordship, because the respondent authorities, more particularly the director of.
Where is the scheme?
Sorry, no.
Which page is the scheme?
Well, the state of Arunachal Pradesh has not framed any pension rules for its employees, but the pension rules of 2021, Central Civil Service pension rules have been.
Yes.
It is,
What is your stand?
it is a covered case, your lordship, actually.
Huh?
It is a covered case, your lordship. Earlier also, your lordship, similar.
Which is the covered order?
It's at page 40, your lordship.
Page 40.
Yes, your lordship.
But Mr.
R.L. Thungam.
R.
L. Thungam.
R. L. Thungam, then counsel for the petitioner. And Mrs.
Arbasar.
Government advocate appearing for all the respondents,
Yes, your lordship.
for all the respondents. Next, madam. The husband of the petitioner, namely Pema Dorji, P-E-M-A, Dorji, D-O-R-J-E-E, Thungon, T-H-U-N-G-O-N, had died in harness on 25/4/2021 while serving as assistant engineer, NAFRA NAF RA subdivision of PWD. Full stop. The petitioner applied for pension and other service benefits. Full stop. The authorities, on the ground that as per order number DAP/PEN/3/2001 dated 17/6/2013 and order number, this is issued by whom? 17/6/2013 is by whom?
2013 by.
Directorate of Audit and Pension.
Directorate of Audit and Pension.
Issued by Directorate of Audit and Pension for Government of Arunachal Pradesh, as well as order number capital VIG-71 oblique 2014 oblique 365 dated 25 to 2020, issued by the government, issued by the Department of Vigilance, Government of Arunachal Pradesh, no objection certificate regarding non-encroachment of government land is required to be submitted for finalization of pension papers. And accordingly, the no, not on the ground. So stop here. Stop. The petitioner had applied for NOC before the Office of the Deputy Commissioner, Bomdila, on 12/8/2022. Full stop. It is claimed that no proceeding is pending against the petitioner for encroachment of government land, and yet the Deputy Commissioner, Bomdila, within bracket respondent number 4, has not issued the no objection certificate. Full stop. Resultantly, the executive engineer, PWD, Bomdila division, has not processed the claim of the petitioner. Hence this writ petition. Next paragraph. In view of the judgment, sorry, in view of the order dated 3/8/2023, passed in WPC 323 of 2022, on a query of the court, the learned government advocate has fairly submitted that the case of the petitioner would also be covered by the decision of this court in the said case. Full stop.
Your Lordship, Executive Engineer had processed the pension papers of the petitioner, but the DC was not issuing the no objection certificate, Your Lordship.
No, he is alleging that it's not processed.
No, he was processing Executive Engineer, Your Lordship.
Where is that?
At page, paragraph 6, Your Lordship.
Paragraph
6 of the petition.
6.
Required documents were submitted, my lord.
Paragraph 6 and paragraph 7, Your Lordship.
No, this is his calculated service benefit.
Yes, Your Lordship. And 7
Except
also.
for, no, that's not processing of papers.
And paragraph 7 also, Your Lordship. Executive Engineer requested a DC for issuing no objection certificate, Your Lordship.
No, then you amend your synopsis. Here you say it's not done. No, don't come with that matter. You see, we rely on you on the basis of your statement. I've started dictating the order.
2 minutes only, I will verify the facts.
You see, you come to your synopsis, what you have written.
Yes, sir.
You have clearly made a mention that there is no process, what you call, the executive, consequently, the executive engineer, last 5 lines. So-and-so Bombay director position I have not processed. Executive engineer has processed. So you're making an incorrect statement. I don't know, you correct it. I'm not giving you a minute. You correct this synopsis. The statement made in the synopsis, I am not reading the entire thing. Why we are asking you to give a synopsis if I have to read everything? You think we are happy with the burdening the lawyers with all these things? Then there is something you have to do, you do it. As this statement made in the synopsis is found contrary to the statement made in paragraph 6 of the writ petition, the court is not inclined to take up the matter. First off, the petitioner shall amend the synopsis to make it in tune with the statement made in the writ petition. First of matter stands adjourned today. List as and when the amendment application is listed.
Item number 10.
Yes, 10.
I think it's adjourned by.
Yes, what has happened?
The petitioner lordship mentioned before, in this case, to file rejoinder, he's taken time lordship. Because for respondent number 4, already we have filed our affidavit lordship. And in response to that, they wanted to file rejoinder. Therefore, adjournment was taken lordship.
Adjournment was taken.
Taken.
Okay. Who took the dictation? Huh? No, mention if it is already adjourned, then don't place it before the court. If the matter has been adjourned, don't place it before the court. I would have passed on this order. Somebody made a mention. Oh, I did not give it. This is I did not give it. Item. From item 10, adjournment was granted. He wanted to file an affidavit against respondent number 4. I gave the dictation. No, I gave the dictation. Mr. Typodia, right?
Yes, Typodia.
Mr. B. Typodia, learned counsel for the petitioner placed for his granted 3 weeks time to file affidavit in reply against affidavit in opposition filed by respondent number 4.
4.
First at least after 3 weeks.
3 weeks.
This is the order I passed.
Item number 14.
My pleasure, Lordship. Before starting, I have a small prayer. In this case, my Lord, I have very recently engaged. I have not gone through the entire brief. On going through the brief, I found that the affidavit in opposition has not been filed on behalf of the.
No, you see, that's what that lies the problem. Yesterday, that is why we asked. You see, I am very conscious of what is coming to me. If you don't, all of you agree to an agreed adjournment, At no cost, I am giving an adjournment because of the fact that there is a direction of the Supreme Court. And if it needs some modification, you have to go to Supreme Court. Unless all of you agree to an adjournment. If not, then I can't adjourn it.
And that is, I have not disputed, my lord. I may be allowed to, because
No,
it
not
is.
you. You have a consent, you go outside, have a deliberation and come back. Correct.
From my part, only yesterday I have given my.
No, I understand, but please understand. You see, what we are doing here is not only with consent of the all sides, it's okay. But otherwise, I'll be flouting the order of the Supreme Court of India,
These directions.
which I can't do.
Correct.
So therefore, there lies no problem. You can go outside,
No,
have
my,
an arm wrestling, come back.
Petition may be admitted or at the admission stage, matter can be disposed of, fixing a date for final disposal may not be convenient of the council what is it?
No, but it is consent of all. You can
Yes.
record it.
and in the meantime, we will be allowed to file affidavit of divorce.
And if rejoinder is necessary, time schedule may be given.
The court has taken into consideration the order dated 8/4/2024 passed by the Supreme Court of India in petition for special leave to appeal within bracket C, number within bracket S, bracket closed, 8145 of 2024, which contains the following observation at paragraph 3, page 53. Full stop. In view of the said directions, the hearing was the hearing of this matter had commenced on 25/2024, and as the hearing could not be concluded, the hearing has spilled over today, i.e. 21/5/2024. Next paragraph. Heard Mr. P.A. Saikal and Senior Counsel assisted by Mr. R.S. Mishra, Counsel for the petitioner, as well as next paragraph. You wanted to file affidavit reply.
So, I'll file in
Okay. Next paragraph. Mr. S. Tapin Lanen, Senior Government Advocate, has submitted that the petitioner has filed IA 66 AB of 2024 on 22/4/2024, whereby prayer is made for bringing on record the subsequent event by way of amendment of the writ petition. Most probably
Now I'm seeking for amendment.
Huh?
That order dated 10/5/2024 reflect that I have not pressing for amendment, only placement can occur. Order dated 10/5/2024.
in this regard, the learned senior counsel for the petitioner has submitted that as per order dated 10/5/2024, he is not pressing for the amendment of the writ petition, and only desires to bring on record the subsequent events. Next paragraph. In that will the matter, the learned senior government advocate prays for some time to file his affidavit in opposition. Correct?
They have already
In
filed.
the main case, we already filed our appeal.
No, in this, in letter of the application,
Yes.
you want to file or you don't want to file?
No, sir, basically, no, sir, I don't have objection in that.
No objection, okay.
Because that part was already submitted by, from our side on last occasion.
Okay. Let's say, in this context, the learned senior government advocate has submitted that the subsequent event which is brought on record is sought to be brought on record by way of IAS Civil 66 AP of 2024 has already been addressed by the state respondents in their affidavit in opposition filed in the in this writ petition. Correct? You are again coming back to the same. He says that he is now not pressing it, and that is recorded in the order dated 10/5.
No.
That he is not asking for amendment.
No.
He is asking to keep on record the subsequent events.
No.
And
Therefore,
it
my
is-
question to you is,
No.
you want to file any objection to that interlocutory application? You said no.
Once it is in brought on record, no, sir, then opportunity must be given to me, no, sir, to.
That's why I'm asking you, but you said no.
No, no, in regards to ILOC, to bring it on record, no, sir. It's one thing, no, sir. After it has been brought on record, no, sir, whether we have any say on that or not, that's another thing, no, sir.
No, this way you're asking you want to file an objection to this.
They have
Some
submitted
You
the-
see, bringing on record means we take it on record. Doesn't mean that he will once again file it and bring it in the writ petition. This IA itself becomes a part of record. This is, High Court is a court of record. Anything which comes here is a part of record.
Then, no, sir, I may be given, no.
That they have already, Lordship, can you see the order to 10/5/2024?
No, I don't know. You see,
No, no,
what
it's
is
recorded.
No, sir, on the.
Sangita,
10?
10/5/2024,
Hmm.
same order, Miller. Second line, Miller. P. Sangita Learned Counsel for respondent number 1 to 6 submits.
No, you
No,
please.
sir, amendment prayer has
This is
been
yeah.
withdrawn
You
yesterday
see,
only.
you are a seasoned lawyer and senior also. You see, I may have no objection, X may have no objection in amendment of the writ petition. But when a writ petition is amended, can I say that you can't object to, can't file a affidavit in opposition?
I have already forgiven this so far as amendment part, it is only placing on record. Same.
So even that he has the right to object.
That is placing on record means the court will look into it.
Court will look into it. Otherwise, you see, an petition for amendment. I don't take cognizance of what is there. Correct.
Yes, yes.
Now you amend your writ petition, then we take cognizance of what is there pleading. You see, very simple. You see order 6, rule 1, CPC. See this.
Pleading.
This applies in writ petition also. Order 6, rule 1 says the plaint and the writ petition and the written statement are pleadings. Only that.
No, here only the.
No. So you see, therefore, I am very cautious of what I am saying. If it is brought on record, then he has a right to object. And therefore, I am asking Mr. Tapen whether he is objecting to it. Now he says yes.
On the previous day, he said no.
No.
You
Mr.
paid for amendment of the writ petition.
No,
He doesn't have objection to this amendment. Now you see.
Now,
Are you are you making a concession
Yes,
that never you will object?
I got it.
Huh.
Yes.
Then,
He may file his objection or counter
yes,
whatever.
it doesn't say you want to amend.
Yes,
You
yes.
want to impede someone, do it.
Yeah.
I have no objection.
Yes.
But after impleading,
Yes.
will someone come and say that no,
Yes.
you consented and therefore no objection now? You can't say that.
Enough.
Accordingly, the senior government advocate praise for him is granted. How much time?
4 weeks.
No, not 4 weeks. Supreme Court says this hearing has make it 2 weeks. Is granted 2 weeks time to file objection to the amendments made in the petition, which is registered as IA Civil 66 AP of 2024. Mr. A.C. Sharma, then a senior counsel, assisted by Mr. B. Halder, counsel for the respondent number.
Respondent number 7.
So that he has gone through the records and finds that the affidavit in opposition of respondent number 7 is not filed. And accordingly, he also prays for and is granted 2 weeks' time to file affidavit in opposition to the matter in the writ petition as well as in respect of the averments made in IS Civil 66 AP of 2024.
We have filed our objection.
First of next matter. The learned senior counsel for the petitioner submits that on receipt of the affidavit in opposition, he will seek instructions and file affidavit in reply if so advised, for which he prays for further 2 weeks' time.
No, madam. But, is there certain 2 weeks time, I pray that the matter, for filing their affidavit, may be fixed on 4/6, madam, matter may be fixed for 10/6/2024. In between, if I, require, I'll file it, madam.
Okay.
So 10/6 should be for disposal of the entire writ petition, madam.
That we don't know.
Can you see the prayer in this very IA also? IA, what prayer has?
You look at this. I don't have that much of time. Look at the order. Look at the order. Look at order 10/5. You have a right to ask for modification of the order.
What I'm submitting is mostly.
No, submission is immaterial. There's a judicial order. You have to file an application for modification of the order if you want to permit him to amend the writ petition. This order has to be recalled. File an application. Consider that.
No, this IA laws. I'm talking about this IA.
This what I have sent was in IA record.
Yes, that's correct, Lordship. Lordship, what I understood is that.
Please think over again and then make your submission. Please think over the submission you are wanting to make.
The matter, that's what the, both the concern of that.
We are otherwise ready for hearing today, sir.
Yes,
You
so
don't take submission.
so I am already have.
For everything you don't have to react.
Here,
So then the best person is Mr. Sharma.
Yes.
You will not find him reacting. That is the best part of Mr. Sharma, and he earns respect for that only. Yes, Mrs. Dafin.
If Lordship see the prayer made in this IA, this interlocutory application. Here, Lordship, it has been paid, Lordship. Please take notice of the subsequent event and the grounds mentioned in the paragraph 8, 9, 10, and 12 of the instant application, and treat the same as a part of the writ petition to be treated as part of the writ petition. And to mold the relief.
What is the order you read?
Lordship.
You see, don't push me to a corner where I say something which will be which will not like it. You see, the court has a power to mold relief. Correct. So we are not bound by the prayers. Number one. So therefore, when there is a judicial order, I told you you have an option only to apply for modification of the order. I can't go beyond the judicial order. I'm not sitting in appeal. Correct. Give a date after 2 weeks so that we give this again the time.
You'll find the 4/6.
Just a moment. Okay, we make it, shall we file on? Shall we file on or before 5/6/2024 Next we list on 10/6/2024, by which time affidavit reply may be filed by the petitioner.
Because we take it up.
We are saying that he'll come or you show us this order again. You just show us the Supreme Court order, we'll again take it up.
But that should be coming for orders in that case.
No, no.
madam. So if it comes for, madam, it is
Whatever,
for
if it is listed, we can take it up anytime.
madam, we taken, madam, listed for admission.
You see, I took up.
But-
Did I tell you that it is not in this stage, I will not take up? So when I found, despite your prayer for adjournment, I took up. Just remind us.
Highly obliged.
Just add one more line there. First of all, therefore, it is made clear that the adjournment of the matter was not at the instance of the court, but at on the prayer made by the respective senior counsel of the counsel for the parties. List on 10/6/2024. I have to say myself.
My lord, Bolo.
May I please, my lord?
Just a moment. You filed an affidavit in opposition?
No, my lord, I have filed my wakalanama today itself, my lord.
Okay.
Therefore, my lord, I need some time to file my reply, my lord. For the respondent number 6, my lord.
Okay. The PWD,
I am appearing not yet filed.
RWD, yes. You're not objecting?
I have not yet filed my
Till
You
date, my
want
lord,
to file?
till date, they have not filed, my lord. If your lordship would see the order of 7/3, my lord. First order, man. Now, since on that day, my lord, the prayer for interim protection was made, my lord, but it was made subject to the appearance of the private respondent. Now, this manner, my lord, the manner in which the tender has been processed, my lord. Totally arbitrary, my lord. And since there is no interim protection, my lord, there is every possibility.
What is the nature of work?
Nature is the construction of bridge, my lord.
This is a development work, we can't stop it.
Now work has already started, my lord.
Work, my lord, of course, I have also taken instructions, my lord. It has been started, but due to the election, my lord, no substantial progress has been made. Only one pit has been dug, my lord, to my information. Because otherwise, this writ petition itself would, my lord, become infructuous. Because the guideline says, my lord, single tender.
We are then giving you about 10 days time to file affidavit.
My lord, okay, we'll file affidavit. Otherwise, the petitioner come belatedly. The tender was in the month of January. He approached this
No,
cause
that's
in the
okay,
month.
but the nature of challenge goes
Yes.
to the root of the matter. It's a single tender.
Yes,
which,
single tender.
according to you, it is your own rule which says it can't be done.
Yeah, that is there. But wrongly
So-
right now work has been already aborted and is started.
So we can stop the work at any point of time. So therefore, we are issuing a notice for the prayer for interim relief.
Yes, we'll file affidavit.
Because, my lord, they say in the reason that there is no time, my lord, to float the fresh tender, my lord. But in the month of the March also, my lord, they were floating tender by the same division, my lord, that I have also.
No,
indexed.
that's different.
Yes, my lord.
Today I may want a pen and I will send my courtmaster to purchase a pen. After some time, after 1 hour, when I find this pencil is not is broken, I'll ask my courtmaster to go and get me a pencil. Correct. So can you accuse the court of saying that okay, at one go you should have sent the person for 2 things. That I am requiring this after 1 hour cannot be a ground for me to ask to go and send him for the pen when I don't want it, pencil.
No, my lord.
No, no.
The manner in which, my lord.
No, no,
because-
we are not dependent on that. Every work has its own connotations.
May I please, my lord,
The-
my lord, can we give 20 days time, my lord, to file it?
No, no, no. You are the, you are enjoying the work. We have already, you see, we have made a statement that the award is subject to further orders.
Yes, my lord, but I have already pushed my missionaries,
No,
my
no,
lord,
we
and
can
I have
stop- we can stop you
work is in
anyway.
progress, my lord.
We can stop you anyway. If the thing is illegal, it is illegal. But Mr. D. Sokil, counsel for the petitioner. Mr. G. Tarak Lanet, study counsel for the RWD.
1 to 5.
And
1 to 5.
respondent number 1 to 5.
Yes.
And Mr.
Opada, my lord.
Lanet, counsel for respondent number 6. Have prayed for 3 weeks' time to file affidavit in opposition in the matter. Next part. In view of the nature of challenge made in this petition, the court is inclined to grant 10 days time to the respondents to file their affidavit in opposition in the matter. Stop. Next paragraph. The court is also inclined to issue notice on the prayer for interim relief, returnable on the next date of listing. Next paragraph. The affidavit in opposition shall be filed at least 1 day prior to the next date of listing. List on list on 29/5/2024.
29. My lord, can you be on 31st? 31st.
Okay, 31st.
Oh, obliged.
Item number 6.
Yes.
My lord, in fact, in view of the actions of the pleading, my lord, on the, as per the last order, my lord, government was supposed to take the instruction.
It's okay.
So far, my lord, what my projected case is, my lord, the
You see,
sports
kickboxing is not there.
kickboxing is not
in
there.
in the Olympics, it is not there in the national games.
And what so far the affidavit is concerned, affidavit said that my lord, they are ready to take, my lord. Government is trying to include the kickboxing in the list of the sport, my lord. Therefore, my lord, up to that, my government was supposed to take the.
We have filed our additional affidavit, Your Lordship, and here we
What
have
do you
said
say?
that kickboxing is not there, it's not included in the list, Your Lordship. So we are going by the.
Kickboxing is not there in the Olympics. It
Yes.
is not there in the national games.
Yes.
So while the government is not included, if it is
Definitely,
in,
they're not included. If it is not a game which is in the Olympics or in the national games, why would they encourage from that? When I was a young kid, I was playing marbles. Now I say that in the marble also, please have a reservation for the job. I played good marbles.
so my lord, if instruction is, my lord,
No,
not
that's okay, but
included,
I'm telling you, see,
then my lord.
Since I have played marbles, I can tell you, it's a very entertaining game. And if you're not, you have missed something.
So madam, in such situation, my lord, if government not included, my lord, matter need to be hard, my lord.
We are
So
hearing
that-
it. We are hearing you.
Otherwise, since the government.
It's okay, we are hearing you.
Yes.
So where is your fundamental right to say that include this in this job in a sports quota? What is your fundamental right?
Well,
How do you derive a fundamental right?
exactly, my lord. What my lord, the base is that all the sports, my lord, so far the sport is concerned, my lord,
many sports which has not been recognized by the National Federation are also included in the game. My lord, this kickboxing is the recognized sports. It is recognized all over the world, my lord. And now, my lord, this kickboxing has been, my lord, already recognized in the sports in the in the India also, my lord. So ministry, there is a notification from the ministry that, my lord, this kickboxing will be included in the sports for the person who are to be appointed in that sports quota, my lord. So, my lord, I will go.
You see, I have opened up the website of the national games. It does not have kickboxing. In martial arts, it is gatka, it is judo, it is kalari, fire two, pancake silat, ske, taekwondo, wushu.
Wushu, boxing, everything, my lord, including kerem
we
and
don't
so
know, but
many
they've
are
issued-
there.
They've issued the included wushu. It doesn't say anything else. If you want details of wushu, it's.
My lord, I will take the lordship to the record, my lord. The annexure A is, my lord, the advertisement, wherein, my lord, this kickboxing was not included. Out of the 63 game, my lord, this was not included. Therefore, my lord, my grievances was that I also applied, but since kickboxing is not there, so my application was not accepted.
Correct.
Therefore, my lord, I have filed a representation before the concerned authority. Now, my lord, may kindly come to the page number 19.
Page 19, yes.
This is the, my lord, general instruction that what type of the person should be in the, my lord, game. So first of all, my lord, without wasting the time reading to everyone, my lord, 2A, my lord.
2A, yes.
Past preparation, past preference to those candidates who have represented the country in the international competition with the clearance of the Department of the Youth Affairs and Sport.
Yes.
Meaning, my lord, person who ever represent the country in the international competition. So in this case, my lord, I am the gold medalist in the international representing India in the, my lord, various states. Now, my lord, may kindly come to page number 21. Whether this kickboxing is included in the, whether this has been accepted by the government of Arunachal Pradesh or not. My lord, page number 21. This is the order of 8 October 2021. My lord, got it? Page 21.
Just a moment. Yes.
Now I'll take to lordship to the page number 21. Three, sub clause 1 of 3. This is the office memorandum of Arunachal Pradesh, 18 October 2021. My lord, got it?
Yes.
Sub clause 1 of 3, my lord. Wherein, my lord, it has been written that, my lord, instruction as issued by the, my lord, department, government of Arunachal Pradesh, government of India, from time to time shall be applicable in the Arunachal Pradesh also, unless specified guidelines are framed by the government of Arunachal Pradesh. The guideline prevailing currently have been consolidated in the, my lord, affix number such and such. Meaning is, my lord, very clear, my lord. If government of Arunachal, government of India, the instruction of the government of India shall be applicable to the government of Arunachal Pradesh.
Yes, please continue.
But so, my lord, what it is undisputedly that the government of Arunachal Pradesh is obliged to the, my lord, this, instruction of the government of India. Now, my lord, to this effect, my lord, I will take the lordship directly to the page number 51, wherein, my lord, on 2nd July 2021, the government of India has, my lord, passed page number 51, my lord.
Page number 51.
My lord. Because these two documents are, my lord, correlated.
Yes.
51, Annexure F. This is, my lord, the subject granting of the recognition to WACO, Indian Kickboxing Federation, for the sport of the kickboxing as National Sport Federation, my lord, NSF, my lord. So, my lord, this subject itself is covered, my lord. Now, India also adopted that the kickboxing will be, my lord, National Sports Federation, my lord. So,
yes.
Therefore, my lord, my contention is very clear that, my lord, now kickboxing is also to be included by the government of Arunachal Pradesh in the, my lord, sports list. Therefore, being aggrieved of this, my lord, I have filed a representation before the concerned authority. Now the authority, so far, my lord, the reply of the affidavit of the authority is concerned that the authority is taking necessary action whether to include or not, particularly in page number, my lord, 6, para 12 of the reply, my lord. That is why, my lord, at the outset of my lord, this proceeding, I said that if the government, my lord, accepted, then my lord, nothing to be heard furthermore. Now, my lord, this is to be disposed on merit, my lord.
Okay. Good.
Thereafter, my lord, annexure, these all other annexure are the national event where I have participated in all the documents, my lord. So I am the meritorious sport person who represent the state, thereafter who represent the country in the various country, my lord, having, I am the person who brought laurel to this country in this field. Now the now the government of Arunachal Pradesh also has already decided that whatever the union government will be adopted, that will be adopted by the government of Arunachal Pradesh. This part clear, my lord. Therefore, my lord, my prayer, limited prayer before the lordship is this kickboxing should have been included and this need to be included, my lord. Now, so my lord, kickboxing may be included and my application pending before the authority may be allowed, my lord, and I may be allowed to participate in that interview, my lord.
Mr. C. Modi, learned counsel for the petitioner, and Mr. Basat and the government advocate appearing for all the respondents,
Lordship.
of the respondents. Next paragraph. The petitioner projects himself to be a meritorious sports person in the field of kickboxing, which is one of the recognized sports of the National Sports Federation. Full stop. The petitioner claims that he has represented the country in the said sports and has also earned a gold medal in the kickboxing championship organized at where? Where is that?
My lord, Harjagabina and my lord, Bosnia and my lord, Herzegovina.
Where is that? Where is the document?
All my lord, my certificate is speak, my lord.
No, it's okay. Just tell us. Give a gap. Excellent. Which was organized by World Association of Kickboxing Organization, within bracket, WAKO for short, bracket closed. Next paragraph. On 19/5/2022, the Department of Geology and Mining had issued an employment advertisement for filling up 2 posts of Assistant Mineral Development Officer under the sports quota. With a condition that the candidate who had meritorious certificate in any one of 63 sports events mentioned in the advertisement full stop. Next paragraph. The application of the petitioner was not accepted on the ground that the sports of kickboxing was not included in these 63 sports events, public games. Full stop. Accordingly, on 26/5/2022 and 27, sorry, first is 27/2021 and 26/5/2022. The petitioner had submitted a representation before the concerned authorities for inclusion of kickboxing in the list of games which would have the effect of granting eligibility to the petitioner to apply as a candidate for the advertised posts. Thanks, Bella. The learned counsel for the petitioner has referred to the office memorandum bearing number 14034/1/95 establishment ESTT dash D. It is D, I'm reading it rightly, page 19. Number so and so establishment dot within bracket D. Issued by the, sorry, it is dated 4/5/1995. Issued by the Ministry of Personnel, comma, P fullstop G fullstop and pensions, comma, Department of Personnel and Training, inter alia providing for first preference to those candidates who have represented the country in an international competition with the clearance of the Department of Youth Affairs and Sports. Full stop. It is submitted that the petitioner qualifies under the said criteria. Full stop. By further referring to the office memorandum dated 8/10/2021, issued by the Department of Administrative Reforms, comma, Government of Arunachal Pradesh, comment is submitted that as per clause 3 within bracket small Roman I, 1 I, 3(1), comma, it is provided that instructions as issued by DOPT, comma, Government of India from time to time shall be applicable in Arunachal Pradesh also, by further stating that unless specific guidelines are framed by Arunachal Pradesh also, comma, unless specific guidelines are framed by Government of Arunachal Pradesh. First off, it was also provided that the guidelines prevailing currently have been consolidated in Appendix -11 of FRSR Roman 1. Full stop. Next paragraph. By referring to the letter bearing F number 9-31/2016-SP-Roman 1/SP-Roman 3 dated 2/7/2021. This is page 51. Committee submitted that the Ministry of Youth Affairs and Sports, Department of Sports, Government of India had granted recognition to WAKO, India Kickboxing Federation, for the sport of kickboxing as a national sports federation. Accordingly, it is submitted that the recognition to the WAKO, India Kickboxing Federation, further establishes the case of the petitioner that he had participated in the International Kickboxing Championship and therefore this is and has earned medals for the country. Next paragraph. Hence, it is submitted that the sport of kickboxing should be included. It should be ordered to be included in the list of games contained in the advertisement, employment advertisement dated 19/5/2022, and accordingly the petitioner, the respondent authorities may be directed to accept the application of the petitioner and process the same. Next paragraph. The learned government advocate has submitted that the sports of kickboxing has not been included. It is the recognized sport for the purpose of the present employment advertisement. And that prior to issuance of the advertisement, the office memorandum dated 1/9/2020 under F number, this is page 5 of the AO, pink glass. Number so and so. Contain the list of 63 sports events where the kickboxing was not included, and therefore kickboxing was not made part of the sports quota in the employment advertisement issued on 19/5/2022. Next paragraph. It is noted that in the office memorandum dated 8/10/2021, issued by the Department of Administrative Reforms, Government of Arunachal Pradesh, it is mentioned that the instructions issued by the DOPT, Government of India, issued from time to time are made applicable in the state of Arunachal Pradesh. And unless a specific guidelines are framed by the government of Arunachal Pradesh, or the guidelines prevailing currently which have been consolidated in Appendix 11 of FR SR1 is applicable. Full stop. In under under Appendix 11 of the FRSR1, if we find in serial number Roman 4, capital Roman 4 of clause A under heading recruitment, there is a list of games, public sports, which qualify meritorious sports persons for consideration for appointment to Group C post under central government, which contains the name of 65 sports events, which does not contain the sports of kickboxing. First off, at the footnote to the said list, there's a mention that the said list was last amended by notification bearing F number 14034/1/2013 dash establishment ESTT full stop within bracket capital D bracket goes comma dated 1st September 2020 comma 29th January 2021 and 17th June 2022. Full stop. Therefore, Appendix 11 to the FRSR-1 does not include the sports of kickboxing as a sports event, which qualify meritorious sportsmen for consideration for appointment to Group C post. Next paragraph. The learned counsel for the petitioner has placed reliance on the grant of recognition to WAKO, India Kickboxing Federation, for the sports of kickboxing as a national sports federation. By memorandum under the page 51, same. Memorandum was dated 2/7/2021. So therefore, the recognition of WAKO India Kickboxing Federation as National Sports Federation on 2/7/2021 is not found to be a condition precedent for the sports qualification, which is found mentioned in the employment advertisement dated 19/5/2022. Stop. The sports which would qualify can only be from the 63 sports events mentioned therein. And the requirement under eligibility clause 3 of the said advertisement is that a candidate should have represented the country in number 1, so within bracket, international competition, comma, within bracket 2, state in a national competition, comma, within bracket 3, university in an inter-university tournaments as tournaments conducted by inter-university sports board, comma, within bracket 4, state schools teams in the national sports or games for schools conducted by the All India School Games Federation in any of the games mentioned in the list of games and awarded national awards in physical efficiency under the National Physical Efficiency Drive. Full stop. Therefore, notwithstanding that the petitioner has earned laurels for the state of Arunachal Pradesh and has earned medals for these said sports events, yet the court does not find the petitioner to be entitled for consideration of his candidature in connection with the employment advertisement dated 19/5/2022, which is impugned in this direct petition. Next, therefore, the rate petition fails and the same is dismissed. Interim order passed on 22/6/2022 stands vacated.
My lord, one word correction, my lord. Whatsoever, my lord, the WACO, my lord, the World Association of Kickboxing Organization. Yeah, during the my lord dictate, my lord has reflected Indian kickboxing.
What did I say?
World or Association of Kickboxing Organization, WACO, my lord, WAKO.
World Association, I think I said that only.
World Association of Kickboxing Organization.
World, WORLD, is that's what I said. World Association of Kickboxing Organization, WAKO for short. Huh? Just I said earlier. Okay.
May I take a lot of indulgence? Item number 14, my lord. In the cost list, my lord, I have seen, my lord, this matter has been marked as part heard. And date have been fixed on 10th of May. What I am informed that for your lordship roster, it is up to 31st. Item number 14.
14, this bench did not hear it.
My lord.
This bench did not hear it.
Well, it's mentioned in the court, cost list, my lord, as part heard.
I don't know. This is not part heard. Item 16.
14.
Oh, acha. Where is 14? Oh, that matter. 14.
Today, yesterday, lordship has heard and
14.
today again, OT some.
14. Oh, somebody has taken dictation. You tell her that this will not be treated as part heard. Okay, right.
Yes.
Okay, right. Otherwise, there will be a problem.
Lordship, again problem.
Thank you for pointing out.
Okay, sir. Is for the other side.
No, it's okay. But thank you for finding it out. You tell her not to be treated as part heard.
My lord, in this matter. My lord, in this matter, my lord,
Just a minute.
all respondents are represented.
There's an office note, respondent 28, 29, 30 is, we have not filed service report.
No, Kato is, CGC is representing.
My lord, I'm for a private respondent. We will file our affidavit.
No, I'm interested in 29, 28, 29, 30.
It's, well, Kato, CGC, Advocate Kato is appearing in this, and we have served the extra copies also.
Yeah, you given it to him?
Yes, we have served extra copies.
When?
Yes, my lord, we have served on 10/4/2024.
10/4.
Yes.
Okay. Who is appearing for CGC?
CGC is the Kato only.
Huh?
Kato, Advocate Marto Kato.
I'm appearing for M. Kato.
I think he is not present.
He left.
One to 4, you have filed an affidavit.
Yes, Your Worship, I'm appearing for 1 and 4. 1 and 4.
One and
we have
four.
filed- Yes.
Who's appearing for others?
I'm for a private respondent for 5/2/26.
No, one by one. 2, 2, 3. First 2, 3, 5. Who's there?
5, my lord, I'm for a respondent of 5/2/27.
2, 3. You are appearing for? You are appearing for no?
5 private respondent.
5.
5/2/27, my lord.
5 to 23. Okay. Mr.
L Rakap. L Rakap.
Takam.
Rakap.
How do I spell it?
RAKAP Rakap.
Rakam. Council. appearing for respondent numbers 5 to 27. Yes, what is your prayer?
Madam, we will file affidavit.
How much time?
2 weeks time.
Oh, okay, the praise fund is granted 2 weeks time to file affidavit in opposition in the matter. Full stop. List after 2 weeks.
May I please, Your Lordship? Your Lordship, I'm appearing for respondent number 3, Your Lordship, official respondent. I beg to pray for some granting of some time, Your Lordship, for filing our counter affidavit, Your Lordship.
This is a very serious allegation. We should notice long back. Non-appearance on call for the petitioner. For the petitioners. Full stop. However, Miss
P. Sangeeta, Your Lordship.
B. Sangeeta, Leonard
P.
D.
P.
Sangeeta. Leonard, you are government advocate?
Yes, Your Lordship.
Government advocate appearing for respondent number
3, official respondent, Your Lordship. Please.
for respondent number 3. Praise for how much time?
3 weeks time, Your Lordship.
3 weeks time to file affidavit in opposition in the matter. Next paragraph. In this case, the petitioners have prayed for an investigation, prayed for a direction for investigation to unearth how the compensation amount totaling rupees 44, 66, 35, 113 was prepared and disbursed without apportionment of compensation to the persons interested. Full stop. Therefore, despite an allegation of misappropriation of such a huge quantity of money, none of the respondents have filed their affidavit in opposition. Next paragraph. Taking note of the fact that notice of motion was issued by order dated 29/9/2022. The court is inclined to grant 2 weeks time to the respondent number 3 to file affidavit in opposition in the matter. Full stop. It is provided that if the affidavit in opposition is not filed within the allowed time, comma, the Deputy Commissioner, Lower Dibang Valley District, Rowing, shall be personally present with all relevant records relating to the compensation under Iluli, ILULI upstream, comma, Iluli, ILULI, ILAPRA, ELAPRA, and sorry, comma, Iluli submergence within bracket rupees 15, 94, 30, 459, and AHALI public ATO public EHALI totaling rupees 44, 66, 35, 113. It's not 43, 43 plus 15, huh? Blue flag. And we prepared to assist the learned government advocate in responding to the court query. Full stop. You are further inclined to record that the respondent numbers 1, 2, 4, and 5, or the pro forma respondent number 6, no, only pro forma number 6. Sorry, it will be 1, 2, and pro forma respondent number 6. Have neither appeared nor paid for any time to file affidavit in opposition in the matter. Full stop. Next for that. The office note dated 9/2/2024 indicates that notice on respondent numbers 4 and 5 was still awaited. Full stop. However, we find from the order dated 14/2/2024 that Mr. K. Saxena, Learned Counsel, had entered appearance for respondent numbers 4 and 5 and asked for time to file affidavit in opposition in the matter. Full stop. In the cause list of the day, it is noted that the name of Mr. K. Saxena as counsel for respondent number 4 and 5 is not reflected. Full stop. Therefore, the registry shall reflect the name of Mr. K. Saxena as counsel for respondent numbers 4 and 5 while listing the matter next. So, time is extended for the said respondents to file their affidavit in opposition in the matter. Next, brother, you give a date after 3 weeks.
May I, Lordship? Lordship, we have received our extra copies only on October 2023. Extra copies for the instructions, Lordship. We have to send extra copies for communication.
Extra copy received on
October 4th, sorry. 4th October 2023.
23.
Yes,
We got a lot of time.
this is coming up for second time after that.
No, I don't know because I get the notice of matters listed today only yesterday night.
Notice was issued on.
No, that's okay. But I get notice of the matters listed in court today, yesterday night. So today at about 8 o'clock, I will get the notice of matters being listed tomorrow. You see, if somebody points a finger at me and say that 5 rupees is misappropriated, maybe I will not be able to sleep for the entire day unless I find out that 5 rupees. And there is an allegation of 30 plus 40, 70 crore rupees being disbursed. And the Deputy Commissioner receives notice, gets a copy in October, is not moved till today. What shall we presume? Thick skin. Thick skin. 2 weeks is okay. He can do it overnight. That's why we are asking his personal appearance. He'll do it overnight. You want time till tomorrow? I'll ensure that the Deputy Commissioner is in your table by tomorrow afternoon. You want a time? You give us a time. We'll ask him to be here tomorrow at that time. Suggest a time.
Yes, Your Lordship.
You suggest a time. Tomorrow afternoon, suggest a time and I'll ensure that the Deputy Commissioner is in your office.
Quite.
I'll have him arrested and brought in on the ground that he is not cooperating with the government advocate.
So
You want to see that?
3 weeks is.
You want to see that exercise of power? I can have him arrested and brought in here. I can do it. So ask him to, I think I am online, ask him to look at this video.
I'm okay with the order, Your Lordship. So 3 weeks for counter affidavit, Your Lordship.
Give a date for personal appearance, filling of respondent number 3, filling. If the affidavit is filed by respondent number 3 by then, my personal appearance is dispensed with. List on, give a date after 3 weeks. Okay. Huh? 12 June. Okay, 12/6/2024.
Affidavit to be filed, Your Lordship.
Affidavit to be filed, affidavit is not filed, personal appearance. with all records.
Your Lordship may, kindly if affidavit is not filed within 3 weeks, after that only it
That's
may
what
be
I
filed.
said.
Your Lordship.
That's why I said, you're fixing it for personal appearance, but if it's filed within 3 weeks, then it is dispensed with. Hmm. You've seen yesterday's viral news. Yesterday, there's a news which is viral. Somebody, some big shot is alleging that the judges don't work. They sit for a few hours a day and enjoy the rest of the time. You've seen the video, no? I'll tell you, it's tomorrow. Yesterday's, I think, Times of India. It's highlighted that the judges don't work. Correct. They perhaps don't know that I received notice of all the matters listed at 9 or 8 o'clock in the evening.
May I please?
Yes.
Well, in this matter, respondent number 7 and 8, they have filed, and respondent number 5 and 6 is they are yet to file the counter affidavit, and the DSGI is not present.
My Lordship, I'm for the Union of India on behalf of M. Carter. We have taken instruction, we'll file affidavit after 4 weeks.
You know, they have taken on 8 April 2024 for 3 weeks.
Yes, my Lord, we have taken instruction from the department, ma'am.
This 2023 matter is husband has died. Husband is died.
Yes.
Yes, my Lord. We have taken instruction from the department.
Huh?
We have taken instruction from the department, so kindly we will file affidavit.
No, that's okay. But what time?
He was killed
Huh?
in the.
How much time? Please tell us.
After 4 weeks, my Lord.
No, 4 weeks is too long.
Any
Usually the husband died when? What is the date of death? 2018.
2018.
Yes, ma'am.
9/8/2018. The representations filed in 2023.
Yes.
Not this as small and transfer for the petitioner. Ms. R. Bassel, government advocate, submits that affidavit in opposition has already been filed by the state respondents. Next para, Mr.
L. Raka, my Lord.
Counsel appearing on behalf of
DSGI.
Mr. M. Carter, Leonard, DSGI. Paid for further 4 weeks time to file affidavit in opposition in the matter. Next para. We take note of the fact that the petitioner alleges that her husband died on 9/8/2018 by a undiffused bomb purportedly left behind by the army personnel after field firing, for which Teju PS UD case number 11 of 2018 under section 174 CRPC was registered. Let's go. On several occasions, on the prayer made by the learned CEC, learned DSJI, public CEC, time was granted to the Government of India respondent numbers 1, 5 and 6 to file their affidavit in opposition in the matter. Full stop. Next paragraph. One last opportunity of 3 weeks is granted to the respondent numbers 1, 5 and 6 to file their affidavit in opposition in the matter. Full stop. It is made clear that if such an affidavit is not filed within the time allowed, comma, the court would invoke the doctrine of non-traverse, and it could be presumed that the Union of India, through the Defense Secretary, comma, Government of India, within bracket respondent number 1, comma, the commanding officer, comma, 82 Mountain Brigade, within bracket respondent number 5, and the General Officer Commander Dash in Chief, comma, Eastern Command, within bracket respondent number 6, have admitted the claim of the petitioner. Full stop. Next paragraph. The learned counsel appearing on behalf of the DSGI is directed to send a downloaded copy of this order to the respondent numbers 1, 5 and 6, comma, which would constitute a notice on them that the court intends to invoke the doctrine of non-traverse in the event an affidavit in opposition is not filed within the time allowed. Next paragraph. Give a date after 3 weeks. List on 11 June is Tuesday, I think. No, make it 12 June.
12 June. Apply.
May I please, your lordship, I'm appearing for respondent 1 and 2 to 4. My lordship, we have received our instructions, but however, your lordship, it's incomplete instructions, so we need to settle this, your lordship. Therefore, your lordship, we may be granted 3 weeks time, your lordship.
Yes, who is appearing for respondent number, private respondent?
My lord, I'm for respondent number 5.
You're not filing affidavit.
Here, my lord, we would like to inform this honorable court that we are no longer representing the respondent.
You can't say that.
My lord, we have been informed by the petitioner himself that they are engaging another counsel. So we are withdrawing our vakalatnama.
We don't know about that. Unless you should have taken a memorandum and filed it before the court. We can't excuse you from appearing. You see, you are young people, you are the future of this High Court. But why don't you read the Guwahati High Court rules? Shows that give this High Court rules. Read chapter 5. I'm growing old, I may not be right, but look at 65, 66, 67, 68. Chapter 5. You're not getting chapter 5.
Yes, I am here, my lord.
Please read 63 onwards. I maybe one or two rule here and there.
Names and particular of parties and in the matter of, then should follow a statement divided into paragraph, setting out to the fact chronologically, which
No. This is what? Which rule? This is which rule? You are reading which rule?
this one is chapter 5A.
Chapter 5A.
Sure.
Please pass it on. Yes, 64. I told you I may be one or two here and there. Chapter 5. Read from chapter, so this is 64 onwards.
Rules for applications under Article 227(1) of the Constitution of
I
India.
don't know. What you are reading, I don't know. Chapter 5, Rule 64, page 51. What you are reading, I don't know. That means you have touched the High Court rules for the first time. Till date, you have never touched this book.
Which one?
Page 51.
Page 51.
Page 50.
You're not getting Rule 64 till now.
Yes, I am here, my lord.
Yes. So go home and read it till 68. Then you will come to know. If you have not read the book once, we can't make you read now.
May I read, my lord?
No, read in your home.
Okay.
Don't spend my time reading the book. If you have not read the book, I can only be sorry. Because if you are a lawyer and you have not read the procedural rules, no point having any deliberation with you. You don't be understanding what I'm saying. If you're not read a procedural law, I'm sorry to say, it's just unbecoming of a lawyer. You can't be in practice without reading the rules. You won't even know how to practice in court without these rules. The day I came to the High Court, I was compelled by my senior to read this and then start my day one in the courtroom. This is the first thing I did. I learned the very hard way. And procedural law is something that, whatever it be, if it is civil procedure code, if it is a criminal procedure code, if it is an evidence act, if it is this High Court rules, criminal court rules and orders, civil court rules and orders, if you don't read, you're wasting your time and also the time of the court. I'm sorry to say that. It may look harsh. You may hear it, you may take it in an unsporting way, but that's the hard reality. This statement would not have been made by you once you have read this. There's a provision how to file it, how Vokatma can be withdrawn. It's a basic elementary requirement. Yes, what was the prayer? I forgot. How much time?
3 weeks time.
3 weeks.
3 weeks time for filing or application.
Outside the represented. So the government advocate has prayed for is granted 3 weeks time to file affidavit in opposition on behalf of respondent numbers 1 to 4.
1 to 4.
Huh?
1 to 4.
Yes, that's right. 1 to 3 is not there.
1 to 3 4.
3 is superintending engineer, 1 to 4. You two. So in view of various office notes, including office note dated 9/2/2024, indicating the answer notice on respect of respondent numbers 6 to 9 are returned back to the registry. The current counsel for the petitioner shall take first steps for service of notice on the respondent numbers 6 to 8 by registered post with ED. What about 9 or 6 to 9 by registered post with ED? Steps within 2 days. Notice is made returnable on. Give a date after 4 weeks. After 4 weeks, give a date. Four weeks. (18/6). No, 18 is Tuesday. Make it 17. 17/6/2024. Oh, no, not 17. It will be make it 19/6/2024. You just say you have for respondent number 5.
Yes.
The counsel for respondent number 5 is present. List on Swenson.
Item number 23.
My play, my lord. My lord, in this matter, my lord, we have taken step to all the respondents. Respondent 478 service report is awaited. So in this case, we may be allowed to serve through Dusty.
Okay. Besides, more than counsel for the petitioners is referred to the office note dated 24/2024. And is submitted that the petitioner may be permitted to take petitioners may be permitted to serve notice on respondent numbers 4, 7, and 8 by Dusty. If a prayer is allowed. Steps within 2 days. Notice is made returnable on within how much time will serve?
Maybe, my lord, 1 week. 1 week. 1 week.
1 week.
7 days.
The notice is made returnable on 3/6/2024. Upon service, an affidavit of service shall be filed prior to the next date of listing. Yes, 1, 2, 3, 5, 6, and 9. Who is appearing?
For 9, I'm appearing, Your Worship.
Yes.
I'm appearing for Union of India.
First time?
3 weeks alone. 3 weeks.
3 weeks. Then give a date after 3 weeks, huh? In the meantime, check a date after 3 weeks. For 9, Ms. R. Basal and Government Advocate, placed for in granted 3 weeks time to file affidavit in opposition in the matter. The respondent numbers 1, 2, and 3.
My lord, we have made a communication, but no instruction was provided.
Mr.
L. Rakab,
Council appearing on behalf of
M. Sat.
Mr. M. Katul and DSGI submits that although he is communicated to the respondent numbers 1 and 2, no response is received. Respondent number 3 is power. 3,
Yes.
3, 3, 6, and 7
Secretary is
is unrepresented.
Lordship, corresponding number. Corresponding number.
conduct
Oh, you're
study
there.
council.
Acha.
Please, please.
Your name?
L. Permi.
Your name?
On behalf of S. Ram, on behalf of L. Permi, standing council.
Your name.
S. Ram.
The council appearing on behalf of the standing council for power department. You don't want to file affidavit? No.
Take instruction.
You want to take instruction whether you are filing an affidavit or not.
I'm appearing on behalf of L. Permi.
That's okay, but you want to file an affidavit? No. First of the Learned Counsel for Respondent number 3 cannot say whether the power department intends to file an affidavit or not. Full stop. Therefore, we presume that the power department is not interested to contest this writ petition.
5 and 6 is represented by studying council land.
No, I don't know. You see, no, somebody is there. You take responsibility of appearance. If you don't know what to speak, don't be here. I'm spending my personal time now. After 4:15, I'm spending my personal time here. Please understand that.
Yes.
I'm spending my personal time here now. I could have gone home and take a rest. If I'm spending my personal time, please cooperate with me. I'm asking you a question. If you don't know what to respond, why be here? You can give a slip. We'll take attendance by slip. No point being here in the court if you can't respond. You see, I was also a lawyer for the first day when I attended the court. You think I had all the knowledge? No. But we are prepared for it. So this can't be an excuse. Once you are a lawyer, you must be thoroughly instructed. You don't have instructions, don't appear. You will save yourself from the outburst of the court. If you don't know the purpose, you are standing here.
The 5
We all-
and 6,
we all-
5 and 6 is represented by Kamdak, but he's not present today.
5 and 6.
Yes, sir.
No, I have said 5 and 6 are unrepresented.
Yes, sir.
Now, this is item 23. No, 5 and 6 is
Secretary and Director Land Department.
land management. 5 and 6 is land management. Who is appearing for 4?
Alert 4 will be NHPC. And no one is
Oh, service report is on 4. Okay. List on. I'll give a date after 3 weeks. You wanted 3 weeks time?
Okay.
Okay. Give a date after 3 weeks. No? 13/6. Okay, 13/6 2022. Okay.
of light.
This views paper, I'm keeping it here.